Okay, good morning, everyone, and thank you for joining us for the Medical Board of California's quarterly board meeting. Pursuant to the provisions of Governor Gavin Newsom's Executive Order N29-20, dated March 17th, 2020, this meeting is being conducted via WebEx. Public comments will be heard for each agenda item for individuals wishing to do so. In order to be ready for public comment, we ask that you please ensure your comment, In order to be ready for public comment, we ask that you please ensure that your comments can be heard clearly by connecting to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting from your device's audio, please click the ellipsis button at the bottom of the WebEx application or the Communicate menu option at the top of the WebEx application, and then select Audio Connection. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that you can use to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will still allow you to participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. President Lawson, you can now start the meeting.
Thank you, Sean, and good morning to everyone. Thanks for joining us here at 9 a.m. I know the meeting yesterday went quite late into the evening, so thank you again, to the members of the public who stuck with us past 8 o'clock last night, and as well as to our staff and to the board members. I would like to ask all of the board members and staff to please turn any devices you have to silent or to mute. Since this meeting is being conducted via WebEx, I will ask all board members and speakers to please announce yourselves by name before speaking for clarity of the official record. All board members are able to unmute themselves and speak at any time during the meeting, but please do place yourselves back on mute when not speaking to reduce the background noise for all participants. Following such online meeting etiquette will ensure the best online audio quality for everyone. During each call for comments from board members and speakers, we will ensure that all comments can be accommodated and are heard before proceeding with the agenda. Government Code 11126 does allow a board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by removing or muting the disruptive people. We do have a time on the agenda for public comment, and we'll ask for public comment on each agenda item. This is an official business meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. During each agenda item, the host moderating this WebEx event will activate the Q&A feature of WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicated they wish to make public comments by name. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment. The host will audibly announce when the 15 seconds remain to conclude the public comment. And after your 3 minutes have lapsed, the individual will be placed back on mute. There is only one public comment per agenda item allowed per attendee. Please do reference page 4 of the agenda for the WebEx instructions on how to connect from the link on the agenda and additional instructions. During agenda item 12, public comments not on the agenda, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for each public comment period. And after 20 minutes, no further comments will be accepted. Again, each person is limited to 3 minutes per agenda item. The board's IT staff will be assisting me with receiving public comments via WebEx during this meeting. I'd like to remind speakers to please stay on topic and keep your comments to the allotted time or less. Today's meeting will be run according to the Open Meeting Act as required by law, and we do plan to end today's meeting at 2 o'clock p.m. I would like to formally call the meeting to order here at 9:05 a.m. and ask that board members please unmute their computers. Ms. Caldwell, please call the roll.
Mr. Brooks. Ms. Campaverde.
Present.
Dr. GnanaDev.
Here.
Dr. Hawkins.
Here.
Dr. Kraus,
Here.
Ms. Lawson,
Here.
Ms. Lubiano,
Here.
Dr. Lewis,
Present.
Dr. Mahmood, Mr. Ryu,
Present.
Dr. Thorpe,
Here.
Mr. Watkins,
Present.
Dr. Yip.
Present.
Thank you.
Thank you. A quorum is present. Board members, please remute your computers. I would like to remind the members again that we will be taking a roll call vote on all action items today. Now we'll move on to agenda item 12, public comment on items not on the agenda. And again, before I ask for public comments, I would ask individuals making comments to please not discuss any pending complaints, pending licensing applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they could provide information to the members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where a decision is still pending. In addition, the board would like to request the public to address the board as a whole and not individual members. And again, please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take today is to listen to the comments and decide whether they'd like a future agenda item on the topic. Unfortunately, no other action can be taken on the item or comment at this meeting. Though this may seem at times like the board's members are not being responsive, following these guidelines is critical to ensure that rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. If you want to comment on an agenda item, please do wait until we get to that agenda item. Comments at this time are only for items not on the agenda. Please do limit your comments to 3 minutes. I will now ask the host to call for public comment. Sean?
Thank you, Ms. Lawson. The Q&A window is open, as well as we will be looking for the raised hands during today's meeting. So if you'd like to make a public comment, please indicate either way. First up, we have Eric Andrus. Eric, are you there?
I'm here. Can you hear me?
Yes, please go ahead.
I want to illustrate my accusation that Bill and other staff members sugarcoat their reports to you, the legislature and the public, and try to make themselves look like they're doing a better job than they actually are. Public Citizen recently came out with a report ranking how often boards hand out serious disciplinary actions. Kentucky came out at the top with the highest rate of serious disciplinary actions, but 32 states had rates that were less than half of Kentucky's. The report says, California had a much lower rate of serious actions, ranking 33rd in the US with a score of 0.85 serious actions per 1,000 for physicians compared to Kentucky's 1.44. If California's rate was as high as Kentucky, they would have a total of 215 more serious disciplinary actions per year. They go on to say, there is no reason to believe that the physicians in any one state are more or less likely to be incompetent than physicians in any other state. Therefore, we believe and observe differences between the boards reflect variations in board performance rather than in physicians' behavior across different states, which perfectly illustrates TJ's conclusions about trends and the onslaught of public letters of reprimand. Remember Alex Smick, the 21-year-old boy that was killed by physician Daniel Hedrick, who overdosed him to death while in rehab and instructed nurses to not check on him during the night? Alex was found the next morning dead, laying in a pile of his own vomit. This board gave Hedrick a public reprimand that Ron Lewis signed off on because, well, you know, you can't hang everybody. And Hedrick then went on public television and bragged about it. Randy Hawkins and Felix Yip were also on panel A at the time. How did you guys vote? Let me play Hedrick's own words for you. Christina, wave your hands at me if you can't hear this.
So I'm here to defend myself, and the medical board now has made their final decision that it was more of a nursing issue. I didn't cause this death. My case was a public reprimand. It's the weakest form. It's still bad. It's on my record, but there's no fine. There's no probation or suspension or classes or anything.
Let me just ask you on this. Why did the medical board even prosecute the case against you then?
Why didn't they just say no grounds here? And
Well, that's what they did.
well,
there
they
was-
said a reprimand. You got reprimanded.
Well, reprimand was for one count because the nurse didn't do what I told her to do.
Notice at the end where he brags that the board just dropped all the other counts so they could use only one count that was enabled them to leave it to a public reprimand. We have tons of cases in our archives that show this very pattern happening all the time. It's going to be really interesting to see what kind of baloney Carrie Webb has concocted to pull over the wool of everyone's eyes on the suggested guidelines coming up next. You can bet I'll be back on that one. Just pay close attention to what she says and how she says it. And then I hope you'll hold her accountable for her words. Thank you.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, I am. Thank you very much. Good morning. I'm Kristen Ogden with Families for Intractable Pain Relief. I appreciate the opportunity to comment, and I hope very soon to see a date posted for your next public stakeholder meeting. There's an important document out as of late yesterday that I asked Ms. Caldwell to forward to board members. I believe she has. It's a legislation and policy brief written by attorney Michael C. Barnes called A More Sensible Surge, Ending DOJ's Indiscriminate Raids of Healthcare Providers. In part, it reads, the federal government has committed to further restricting the availability of prescription opioid medication. To that end, the Department of Justice has implemented an aggressive effort to shut down rogue prescribers and pharmacists. However, as a part of this effort, the DOJ has raided, searched, and investigated nationally recognized leaders in pain management and also in addiction medicine. It goes on to name 4 of those doctors, Dr. Lynn Webster of Utah, Dr. Forrest Tennant of West Covina, California, the immediate past president of the American Society of Addiction Medicine, and also the past president of its affiliate in Tennessee. None of these influential physicians has ever been charged with a crime. Dr. Forrest Tennant, of course, is the doctor that our members, most of them, were treated by until he felt pressed to retire in 2018. He was honored in September of 2017 by his peers at Pain Week with a Lifetime Achievement Award for his contributions to pain medicine. 2 months later, in November of 2017, DEA agents raided his home and offices after having investigated him. For a decade, he had served as the editor-in-chief of Practical Pain Management Medical Journal, which provides research insights and information on best practices in pain medicine. He had served as mayor of West Covina, California, been very involved in community and civic activities, and has made significant contributions via his charitable foundation. He practiced as a specialist in intractable pain care in West Covina for over 40 years. He treated people with intractable pain and the complex conditions that go with them. One patient of his said, I believe many of Dr. Tennant's patients will die because they will never find another doctor to treat their painful condition. It concludes, in part, not all healthcare professionals subject to the DOJ searches and seizures are dirty docs. In fact, some of them are nationally recognized leaders, not just in pain management, but also in addiction medicine. Our issue is not about bad doctors, it's about the loss of a great doctor. Please help us take immediate action to bring Dr. Tennant and his associates back to active practice. His associates still are, for the most part. Pick up the phone and invite him to come back. If you implement a demonstration project, we believe this will be an easy and quick way to get pain care available again to tragically ill people, some of whom have already died. We appreciate the opportunity to speak at this meeting, and I look forward to being involved in an intractable pain advisory committee. Thank you.
Thank you for your public comment. Next up, we have Virginia Farr.
Hi, good morning. First of all, I agree with the previous caller. Having chronic pain for 3 years, I could not imagine having pain in this nowadays, how pain is managed. Yeah, it would be horrible. Second, I'm curious if the bills are read before you guys come to meeting, because it seems like you don't know a lot about them, and it's really concerning to me, especially those who don't practice medicine, members of the public. Like, do you look up fluoroscopy and know like the risk and benefits, and look up MAUD and see the amount of injuries and know what the injuries are before you make votes? And how long do these doctors have to practice in another state before they can practice in California? Is it like a week or is it a year? And what education must they have in the other states before they can practice here? And JACO recommends education every year because this device is so dangerous. So I'm just curious what the general public knows about these medical devices before they vote on them. Also for AB 278, the limit is $10 that needs to be reported. And with it in writing, it greatly impacts workflow, which greatly impacts patient safety because you're adding stress to a stress system already. And it mentions that the physicians can just figure it out. They'll figure it out through shortcuts, and shortcuts cause patient harm. And also when you look at open payment website, which I did to the device which that lady was hurt, it lists the name of the pharmacy or the device manufacturer, but not the device. So the patient still might not know what device it is. Without my knowledge in it, I would not have known, it wouldn't have helped me. And lastly, on AB 562, the mental health healthcare workers, you're dealing with a highly traumatized population, except there's no formal training required in trauma therapy and the recommended modalities, which is coaching and counseling and similar. There's no trauma required training. So you're sending traumatized people to modalities that likely have no clue how to deal with trauma, which likely will make it worse. And lastly, let's take a moment of silence for the 30 people today that will be injured in the medical system by doctors that are reported, and for the hundreds of others that won't be reported. I know statistically that's not a big number for the hundreds, thousands that are treated well, but those 30 people today that are hurt, their lives will never be the same, and they will understand what MICRA is, how the medical board functions, how the whole world, how the whole system is against them. So please just take a moment of time for these people whose lives will never be the same after today. Thank you.
Thank you for your public comment. Next up, we have Wendy Connect. Wendy, are you there?
I'm here. Can you hear me?
Yes, we can. Please go ahead.
Great. Sorry for yesterday. I don't know what happened. It was screaming, but anyway, I want to just take a moment to add to some of the comments about AB 1278 and thank the board for supporting the bill and for all the people that called in. You know, I know you've heard about me. I am the patient that was the impetus for this bill. I am, or so I thought I was, an informed consumer. My husband is a doctor. We know how to ask the right questions, but you cannot ask the right questions without all the information you need to know. What happened to me can happen to anyone. AB 1278 is absolutely about patient protection. If doctors are truly against transparency, then I have to question if they have something to hide. These are the doctors that AB 1278 is protecting patients from. Protecting them from the harm, pain, and suffering that I and many others have had to endure. Transparency is good for doctors. It creates trust. Focus groups have shown that most patients don't really care about these affiliations, and some will even view it as a positive. Important to note, the disclosure of payments is not an indicator of wrongdoing or illegal conduct. One thing we know is that when doctors do disclose, it creates a bond with a patient. That's because it's the right thing to do. But think about the opioid crisis. Think about the opioids that drug companies incentivized doctors to prescribe that addicted and killed hundreds and thousands of patients, and the high cost of prescribing brand name drugs over less costly generic drugs. Don't you think disclosure would have modified many doctors' behaviors? Would they have thought twice if they had to disclose that they were being paid? And as the last caller said, if we use open payments as a reference, anything over $10 of value is listed. We know from studies that even, and that seems to be working with open payments, and we know from studies that even a lunch can influence the behavior. Kaiser Permanente, some universities, and many physician practices have even banned lunches from reps. As far as implementation goes, a simple solution, non-disruptive, is to give the same info to every patient when they check in. With disclosure, patients can then ask or not ask questions if it pertains to their personal treatment. The mere act of receiving payments is not perceived as a conflict of interest, nor is it disclosing to the patients as a conflict. It's only the actions after they receive the payments that could be a conflict. It seems long overdue. Doctors have to disclose if they're sending you to a facility they have a financial interest in, but not a drug or device that they're prescribing for you to ingest or implant inside you. Doesn't that seem crazy? All patients need the information.
Please proceed.
Okay, thank you. All patients need this essential information to allow them to ask the right questions. That is informed consent. Thank you so much for supporting this bill.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yes, hi, good morning. Can you hear me?
Yes, we can. Please go ahead.
Okay, thank you. I'm Susan Lauren, surgical assault survivor and activist educator who is exposing the harm that board-certified plastic surgeons and others do to healthy people. Last night, there was a bill regarding Alzheimer medication training that was discussed. Science shows that removal of subcutaneous fat tissue creates an increase in visceral fat and also hypertrophy in remaining sub-Q fat. This happens over time, regardless of maintaining a healthy diet and exercise routine. Visceral fat increases risk for type 2 diabetes, insulin resistance, heart disease, stroke, metabolic syndrome, Alzheimer's disease, and more. The secretions from visceral fat go directly to the liver and may interfere with the vital roles it plays in helping regulate levels of glucose and cholesterol in the blood. Also, studies have shown that larger cells are more active metabolically than small ones and likely to spew harmful substances into the bloodstream. Now, before I went for medically recommended breast reduction, I hiked and worked out for hours a day. It was my love. I was muscular, limber, and radiantly healthy. I was a physical movement behavioral therapist who was careful with my health. I did not go to have a surgeon stab me up and remove liters of fat. In addition to the physical mutilation from unconsented aggressive stabbing into my sciatic notch, my iliotibial bands, hamstrings, hip bones, kneecaps, and more, I'm systematically ill from the removal of liters of needed tissue that Saul Berger took from me without informing me, without my consent, without any reason whatsoever, while I was asleep under his licensed care. I've provided this board with article and study links and patient experience detailing these bad adipose removal outcomes. The best article can be found by searching "The Dangers of Liposuction, Rogue Health and Fitness." That's Rogue, R-O-G-U-E, The Dangers of Liposuction at Rogue Health and Fitness. A molecular biochemist that researches leptin told me this was the best article he found on lipo, and he supports my work. I'm not paying you for a dinner, but this article is good. Okay. In the name of public health, it's time to look at plastic surgery in an updated, informed way. Without understanding the endocrine organ of fat, surgeons remove needed cells. They cause thousands of healthy people to be hurt, disfigured, have an increase in disease processes. Adipose removal is making our population sick in the long term. Prevention is far better than pills, so let's stop allowing doctors to create health problems. Also, it's a disgrace that this board let Saul Berger, my assaulter, continue to practice. He should be in jail for what he did to me, and I insist on changes to the public to protect the public. Thank you.
Thank you for your public comment. Next up, we have Anne Fuqua. Anne, are you there?
Yes,
I got that last name right?
Can you hear me?
Sorry. Yes, we
Can you
can.
hear me? Okay. My name is Anne Fuqua. I am a member of the National Pain Council Community Board. Prior to being in a wheelchair, I was a registered nurse. I have primary generalized dystonia and arachnoiditis. For the past 20 years, I have been on opioids for chronic pain. These medications have given me the ability to have a good quality of life. I was treated by Dr. Forrest Tennant prior to his retirement in 2018. As a patient, I live in fear of losing access to medications that allow me to live a full life. I would ask that you ensure physicians can treat patients like me via the Intractable Pain Act without fearing for losing their license. Thank you.
Thank you for your public comment. I did see a hand go up from somebody, but it has since gone down, so I believe that is all in queue, Ms. Lawson.
All right, thank you, Sean.
I'm sorry.
Now we're going to
going up and down.
Okay.
Okay. Next up, we have Khadija Lang. Hope I'm getting that name right.
Yes. Can you hear
Yes,
me?
we can hear you. Yes, we can. Please go ahead.
Good morning. This is Dr. Khadija Lang, and I'm president of Golden State Medical Association. We are the California branch of the nation's oldest medical orgs representing nations of Africa.
Sorry, Dr. Lang, your connection seems to be cutting in and out. It sounds like you're maybe on a mobile device.
As we have mentioned on multiple occasions, the board has taken some steps, including bias training, in an effort to address problems found by the study. And we feel that after 4 years, there should be some indication of whether or not those steps taken have made a difference and had an impact. We think that it's extremely important for the protection of the consumers of this state that those physicians who are providing care for doctors and all hear a lot of concerns and complaints from patients that are not happy with the care they're receiving from their licensed physicians. We're calling to speak on behalf of the concerns of those consumers who are very happy with care and the quality of care and treatment they receive from physicians, but then end up losing the ability to make that choice on who will provide their care due to things that showed up in the findings of the demographic study at California Research Bureau. At this point, we think it is time for the medical board to take a look and see whether or not the steps you have taken and implemented in presumably an honest effort to make a difference in the unfortunate and negative findings of that study in 2017 are actually being positively impacted, and whether or not we're actually achieving desired effect, i.e. a change in those findings. So I would like to ask that the medical board look at how they're going to reassess what's been done thus far, see whether or not that is going to, as actually having the desired effect. We don't want you to be spending the limited resources that you have doing the same thing over and over. It is not making a difference in the area that you are hoping to take. So we think it's time to take a look at the Medical Association. Golden State Medical Association is more happy to be members
30
of any
seconds
type
for me.
to be a member of any type of advisory board that you may want. We have participated before under the direction of Ms. Kim Kirschmeyer when this was first started up, and we welcome an opportunity to provide information and insight and assist the board in seeing how they can better achieve this goal. So I thank you for the time to speak.
Thank you for your public comment. Ms. Lawson, that is the end of the queue.
Thank you, Sean, and thank you to all the members of the public who took the time to be with us this morning and to provide your comments. Yesterday, we were unable to finish all of the items on the agenda, so before we move on to item 13, we're going to be going back to item 10A for discussion of one bill and also 10B for discussion of the regulations. So I think, Aaron Bone, are you here and are you ready?
I am, and I'm willing as well, Madam President. Good morning.
Thank you.
Senate Bill 57 authorizes certain local governments to establish temporarily overdose prevention programs within their respective jurisdiction. These programs would provide a hygienic location where individuals may consume controlled substances under the supervision of staff who will intervene in case of a serious health event. At these locations, participants will be offered sterile consumption equipment, general medical advice, including referrals for medical care, substance use, disorder treatment, housing options, and other social services. The bill's language generally provides for criminal, civil, administrative, and professional disciplinary protection for the employees, volunteers, and others involved in the operations of these facilities, except for conduct performed in a grossly negligent manner or in bad faith. Following the board's prior meeting, we were fortunate to have a discussion with the author and the sponsors staff, and the bill was amended following that meeting to specify that the liability protections do not limit the medical board or the osteopathic medical board from taking administrative or disciplinary action against its licensees for any action, conduct, or omission at these facilities that may violate the Medical Practice Act. We greatly appreciate the author and sponsor for agreeing to this amendment. Staff recommend the board adopt a neutral position, but direct staff in a position letter to explain the board's views on the value of this liability protection language that exists in the bill, specifically the language that allows the board to continue to enforce the Medical Practice Act. I'll turn it back to you, Madam President, for a discussion and a possible motion.
Thank you, Mr. Bone. Any comments, questions from board members?
Can I make a motion to support Senate Bill 57?
And I'll second that.
Thank you, Dr. Lewis. Thank you, Mr. Watkins.
Excuse me, is that a
Is there any
support? Is that a support recommendation?
I make a motion to support Senate Bill 57. Did you get that, Aaron?
I did. I was just to clarify, does that mean the board is entirely supportive of all the aspects of the program, or just want to clarify if the board was really supportive of that language that I mentioned that preserves our opportunity to take disciplinary action?
Well, we should have the opportunity to take disciplinary action, but you're now telling us that it's not in the bill.
To clarify, Dr. No, that language is already in the bill.
Well, that's right.
Yes. So, but the reason why we brought this bill is not because of the broader public health objective, because that goes beyond the medical board's, jurisdiction. The reason why this bill was brought last meeting was because there was a inappropriate liability protection, which now has been addressed by the author and the sponsor. So the staff do not recommend a support position for the bill entirely, but rather a neutral position, because our concerns were addressed relative to our discussion last time. So instead, a neutral position is what we're recommending. However, we would express our appreciation and thanks for that amendment that they took. Does that help clarify, Doctor?
It's becoming clear. So you like the motion to be we support a neutral position.
Yes.
Period.
Yes, the recommendation is the board adopt a neutral position.
Okay, I'll go with that motion, a neutral position on Senate Bill 57.
Thank you.
Aaron, I have a question.
Yes.
My question is that since this was, when we discussed it the last time, we had issues with the liability portion of it. We did not have real concerns about the broader issue that I think the board felt should be addressed. Our component was did this limit the board's ability to take action against doctors that abuse that privilege, right? Now we have language that says, yeah, that's been addressed. Now, we only have to determine if that is adequately addressed in order to support that. So I don't understand why the staff recommended a neutral position if we are in an agreement on the principle of it, and we've addressed this deal. Maybe you can explain that, and that will clarify how we will move and all of it. Thank you.
Sure, happy to, Mr. Watkins. Appreciate the question. If it were not for the concerning liability protection language that was in the prior version of the bill, the staff would not have brought this to the board. The overall goal is a public health goal, and it does not pertain to our licensing and disciplinary programs. However, because when that bill was introduced, as we monitor legislation, we noticed the language at the time would have completely prevented the board seemingly from taking any disciplinary action, even in potentially egregious violations of the Medical Practice Act. That was concerning to staff, and so therefore we agendized it with the president's permission at the prior board meeting. The concern that led to us agendizing the bill, Mr. Watkins, has been addressed through the amendment that I referenced. And so therefore we're left with a bill that now does not have anything to do with the medical board, does not intersect with the medical board's concerns as we are able to take action. And therefore the neutral position is what the staff are recommending, because the bill now, the broader issues of public health and safe injection and that sort of thing are beyond the board's jurisdiction. Is that helpful, Mr. Watkins?
That's actually very clear, because that lines up with another case that we had yesterday that basically established what is in the board's domain, what's in our lane and what's outside of our lane, even though on the periphery it affects what we do, what happens in the broader public health space. So
Yeah,
that makes it clear. So now I understand the neutral position. Thank you.
My pleasure. So I
Are
saw
there
we
any
had
other
a
comments
motion
board
from.
members? Yeah, any other comments from board members? Dr. Lewis, would you like to revise your motion to be consistent with the staff recommendation, or would you like to take an alternative position?
No, I just, I already had before Aaron spoke to recommend a neutral position. That's now the motion according to recommendations from staff.
And I'll second that.
Thank you. And
Ms.
Mr. Watkins, are
Lawson.
you in agreement as a seconder?
Yes.
Thank you.
Ms. Lawson, may I
Dr.
comment?
Krause? Please.
I'm in favor of the neutral position, but I want to clarify something which stated by Mr. Bone. And that is to say that the board is not precluded from taking positions on bills, even if it's not clear that it's in direct relation to the primary mission of the medical board. I would remind us all that we are responsible for consumer protection. So if there is a healthcare related bill that relates to consumer protection, and in many ways, a safe injection site could be viewed in that manner. If we had strong feelings about that, the board could certainly take a support position for a bill of this nature. But I agree that in this particular circumstance, neutral is the appropriate position. But I wouldn't want board members to think that the rails are so tightly defined that we cannot look at other bills that may be outside the primary mission of the board, if indeed they relate to healthcare and consumer protection.
Thank you, Dr. Krause. Of course, of course that's correct. And I mean, we do, when we're preparing the agendas, have a particular eye as well on what types of legislation we are reviewing. Mr. Watkins, did you have another comment?
I just want to thank Dr. Krause for that. That's an extremely important point.
Thank you. Additional comments or questions from the board before we go to public comment? All right, I'll now ask Sean to call for public comment, please.
Okay, the Q&A window is opened up, and the raise hand feature is enabled again for anyone wishing to make public comment on this legislative item. First up, we have Virginia Farr. Virginia, are you there?
Yes, I was just wondering, since it's pre-obtained drugs, that they're likely high in fentanyl, and is there safety measures in place and proper staffing and proper equipment to manage this that don't put the healthcare workers at risk or the patients at risk? That's my only question. Thank you.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thanks, Sean. We'll bring it back to the board. We do have a motion by Dr. Lewis, a second by Mr. Watkins on the table. Is there any further discussion before I call for the roll call vote? All right, seeing none. Valerie, please call the roll.
Mr. Brooks,
Yes.
Ms. Campoverde,
Aye.
Dr. GnanaDev,
Yes.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Miss Lawson,
Yes.
Miss Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Mr. Ryu,
Aye.
Dr. Thorpe,
Aye.
Mr. Watkins,
Aye.
Dr. Yip,
Aye.
Thank you. The motion carries. We'll now move on to agenda item 10B, regulatory action.
Thank you, Madam President. This is the status of pending regulations per the chart that's in the meeting materials, and staff are happy to answer any questions that the members may have on the status of those regs.
Hi, this is Carrie, and I do want to inform the board that the proposed regulations for the Physician Health and Wellness Program have been submitted to the Department of Consumer Affairs for review.
Thank you. Do any board members have any questions or comments on the regulatory action? All right, seeing none, we will take public comment to the extent there is any. Sean, would you like to open up that line, please?
Yes, I've opened the Q&A window and also activated the raise your hand functions if anybody would like to make a public comment. I'll give you a few more seconds here.
I'm sorry, Sean, did you say there wasn't any public comment, or is there someone coming on?
I don't see any this time. I was giving them a few seconds just in case people were
Great.
trying to queue up, but at this time I don't see any requests.
Okay, thanks very much, Sean. We'll bring it back to the board. And Ms. Webb, do we need any sort of action here? Motion to approve. I don't think we're taking any action.
No
okay,
action.
Great. Thank you. We will move on now to back to our agenda for today, to agenda item number 13, presentation on disciplinary guidelines. Ms. Webb.
Thank you very much. Sean's going to give me authorization here to share my screen. There we are. Okay. So thank you very much for this opportunity to talk about the disciplinary guidelines. I know it's been a hot topic of late, and almost all the board members have had this training or similar training on how the board uses the disciplinary guidelines. And but I think this is, in my humble opinion, the most important role for board members, and that is taking appropriate disciplinary actions on licensees who violate the Medical Practice Act. And so it is a very important refresher, and I'm very happy to give this presentation today. So as we all know, the board's priority is to protect the public. And so in the administration section of the Medical Practice Act, it's laid out per statute that public protection shall be paramount. And that needs to be on top of everyone's mind when they are imposing discipline, when they're voting on proposed legislation, regulations, and determining the board's policy. Public protection is paramount. This is also emphasized in the enforcement section of the Medical Practice Act and directs administrative law judges as well as the board, when exercising their disciplinary authority, to make public protection paramount. This section, Business and Professions Code 2229, also calls for action to rehabilitate the licensee so long as it's not inconsistent with public protection. How is this applied? I think that that's an important question. What does this mean? And in cases where the licensee has demonstrated that they've taken responsibility for their actions, they've taken steps to correct the error, then the ALJs and the board may interpret this to mean that discipline short of revocation is appropriate. If someone can be rehabilitated and the public still be protected, then revocation may not be the appropriate penalty. And just to recap, the goal of discipline is consumer protection and rehabilitation of the licensee so long as it is not consistent with consumer protection. The board does not have the authority to impose punishment. And what happens if the board oversteps, you may be asking? Well, the licensee can, first of all, file a petition for reconsideration that goes to the board, and the board may grant the petition for reconsideration, and that matter would come back before the board panel for oral argument. And the board members would have the transcript of the hearing from the matter that appeared before the administrative law judge, and all of the evidence in the case, and the board can make the determination to change the penalty or to adopt it as is. If that is not successful or the licensee chooses not to petition for reconsideration, they can file a writ with Superior Court. And if the court determines that the board did not prove its case for every action, then it can remand it back to the board for reconsideration of the findings and reconsideration of the penalty. And this does happen. It happened in both panels just at this board meeting. So there's checks and balances, and I think that that's important. The board can't just impose a course or impose a period of probation that is not supported by the evidence as being required for public protection and being tied to the facts of that case. So the purpose of the disciplinary guidelines is to assist the board in evaluating cases. It does help foster uniformity and consistency and fairness. It should act as a deterrence because the terms and conditions have an impact on the licensee's ability to practice. But at the same time, the guidelines must be flexible and account for the myriad of variables in each case. And in fact, page 1 of the guidelines says these guidelines are not binding standards. Page 2 indicates that absent mitigating circumstances or other appropriate circumstances, the administrative law judges and the board will follow the guidelines. But there often are factors that must be considered when determining whether strict adherence to the guidelines is appropriate. So that has to be explained if there is a deviation from the guidelines. We'll get more into that as we go along. But the structure of the guidelines is that they contain model orders. They're organized by the code sections violated. They show guidelines for levels of discipline. They contain standard and optional conditions of probation. And these are created through regulation. And so the board is on the 12th edition. So it goes through a very public process, and the guidelines are incorporated by reference to the board's regulations. The guidelines are applicable to both proposed decisions and proposed stipulations, and the proposed decisions go through a full administrative hearing with an administrative law judge. the proposed stipulations are reached between the parties, which are the respondent and the board executive staff. So the proposed STIPs have to be agreed to by the executive director, in some cases the deputy director, and in some cases the chief of enforcement. This is reached prior to a hearing, but it often does involve input from the administrative law judge because settlement negotiations are part of the process, and the parties are expected to engage in meaningful settlement discussions. It's built into the Administrative Procedures Act. But proposed decisions and proposed stipulations are different. Both must consider the guidelines, but a proposed decision must state the reasons for deviation from the guidelines in the proposed decision. A stipulation does not include the proposed reasons for deviation from the guidelines in the stipulation itself. And I'm sure people are wondering why that is the case. And it's because by law, settlement negotiations are confidential because they're designed to promote a resolution without the need for a hearing. And the parties would not want to prejudice their case by having their being agreeable to a settlement used against them at a hearing. That would undermine the process. So the confidential reasons for a proposed stipulation are, while it's not included in the stipulated agreement itself, it is included in the DAG memo. That's the Deputy Attorney General memo that accompanies every proposed stipulation. If no settlement is reached or if the board rejects it, then the settlement discussions cannot be used against either party at hearing. So the process for reviewing proposed decisions, the recommended process would be to review the accusation and make note of the allegations. But remember that the accusation is written and filed before there is an exchange of discovery and before the Deputy Attorney General receives the licensee's expert report. So the charges in the accusation have not been proven yet. You read the accusation, read the proposed decision, determine what allegations, if any, have been sustained by clear and convincing evidence. That is the burden that this board in this state must meet. But that's not the burden of proof in every state. Some states, including the states referenced in the Public Citizen Report, only have a preponderance of the evidence level of burden of proof, much lower than the clear and convincing evidence standard. So that is the burden of proof that this board must prove. And if it's not proven, if you only reach the preponderance of the evidence standard, then the ALJ is obligated to dismiss that charge and potentially the entire case. That's true even if there's one simple negligent act found to have been proven. The board does not have jurisdiction to impose discipline on one simple negligent act. And if a case like that goes to hearing, then you would expect that the administrative law judge would dismiss the action. When you're reviewing the proposed decision, you're looking at what evidence is cited in support of the conclusion. And this is described in the factual findings of the proposed decision. And you're going to review the disciplinary guidelines, determine what is the suggested discipline for each allegation, and determine whether the discipline order follows the guidelines for those violations. If it doesn't, what's the explanation? There must be an explanation in the proposed decision for deviation from the guidelines. And if it's not there, that would be a reason for a member to hold the proposed decision. And it's imperative that you do. So you are going to determine whether the discipline provides sufficient consumer protection, and where possible and not inconsistent with consumer protection, rehabilitation of the licensee. Per our code section 2335, the board shall give great weight to the findings of fact from the administrative law judge. And we'll come back to how this impacts decisions shortly. So after you review and consider the proposed decision in light of the accusation, in light of the disciplinary guidelines, members vote to adopt or hold that proposed decision for discussion and final action during a board panel meeting. So it takes 2 members to hold a decision for it to go for discussion at a panel meeting. And at that point, the members can choose to adopt it as is, choose to non-adopt it, in which case the proposed decision would come back for oral argument, and the members will get the transcript of the underlying hearing and all of the evidence, as well as written argument from both parties for their consideration. With proposed STIPs, similar process: review the accusation, review the disciplinary guidelines, read the proposed stipulation. And what's different here is that you have a memo from the Deputy Attorney General, and this describes the post-filing developments, which could include what happened during discovery exchange, the strength and credibility of the prosecution and defense witnesses, and qualifications of the experts, whether there's disagreement, whether experts have changed their mind based on the discovery that was exchanged. And that does happen. And if there is new information, experts, if it changes their opinion, they're expected to say so and not maintain an opinion that cannot be supported by the evidence. So there's a lot included in the Deputy Attorney General memos that explain the strengths and weaknesses of the case, and they give a recommendation on why the proposed stipulation is appropriate in this particular case. And again, if it deviates from the disciplinary guidelines, the justification for why it does so must be included. And the members need to determine if that is good enough, and if it makes sense, and if it's supportive of consumer protection as the highest priority of this board. And where possible, it has to, again, provide for rehabilitation of the licensee. An example is if you have a medical record keeping violation, but the proposed stipulation does not include a course to address medical record keeping, then that would be a reason to hold it for discussion to ensure that that gets addressed. So you're going to review the information and vote to adopt or hold the proposed stipulation. If you vote to hold it, again, 2 members have to hold it for it to appear for discussion at the next board meeting. So there's a lot of concern about what would warrant a deviation from the disciplinary guidelines. And so many things go into this. Many licensees, once they realize that they have made an error, many even before it comes to the board's attention, they will start taking corrective actions. They'll take courses, they'll change policies in their medical practice, and that becomes evidence that must be considered in a case. There are some cases where witness availability is an issue. Many of these cases do not require patient testimony at hearing, but sometimes it's imperative, and sometimes those witnesses are not available, or they have credibility issues. We've already talked about the role of experts and how the reality is that expert credibility and differences of opinion must factor into whether a proposed stipulation is appropriate versus taking the risk of going to hearing. Also, the age of the violation, if it's been quite some time, and sometimes this happens because the board doesn't receive a complaint for years, maybe even after a civil matter has been resolved. But the fact that there hasn't been an issue before the violation or after the violation and the physician has continued to be in practice, that's something that can factor into whether a proposed stipulation is appropriate. The value of more immediate discipline. Stipulations that are rejected right now, it's probably going to be a year or more before the matter goes to hearing. And so the members need to decide whether having discipline imposed now, which could include practice monitoring, no solo practice, courses, whether the value of that being imposed now is an important factor versus waiting a year for it to go to hearing, not knowing what will be found at that hearing. And then the level of certainty that discipline will be obtained at hearing. We talked about the fact that one simple departure does not give the board jurisdiction to impose discipline. And so you can have a case where you may be going forward on repeated negligent acts where there's, say, 3 acts that are at issue. If the administrative law judge finds that there's not evidence to support 2 out of the 3, and you're left with one simple negligent act, then the administrative law judge is obligated to dismiss that case. Yes, the proposed decision will come to the board. The board can take a look at that. But remember up above where we said the board is obligated to give great weight to the findings of fact by the administrative law judge. So sometimes those findings can pose an issue for the board imposing a different decision because it gives grounds for the decision to be challenged, which is expensive and time consuming. And in the meantime, discipline may be stayed or ultimately be not imposed at all. So a proposed stip sometimes gives the board the ability to impose discipline because the licensee is agreeing to it. And that may not happen if it goes to hearing and the administrative law judge does not find support for those charges. So that brings us to how a deviation from the disciplinary guidelines can ever be consistent with the board's mission. And it's when, under the facts of that case, the stipulation provides sufficient patient protection and imposes appropriate rehabilitation measures. And this is done in a timely manner. Sometimes the proposed stipulation will even include conditions that the licensee agrees to that you may not be able to get from an administrative law judge. There is an opportunity to be more creative with the proposed stipulation. And some of the things that get factored in, for example, many of the guidelines call for 5 years probation, but the proposed stipulation may call for 3. But you look at the terms and conditions included within that discipline, and it may require a clinical evaluation from PACE through UC San Diego, for example. That's a very robust evaluation. And that may be something that if it goes to hearing, you may get education course requirement, but you may not get a full clinical evaluation requirement. And so that's something that must be weighed along with not just the length of the probation, but what conditions are included in that. So the role of stipulations is that they provide certainty. You know that discipline is being imposed. You are not taking a risk of it going to hearing. And sometimes it can frankly be uncomfortable. There's a lot to weigh in this. And these are not easy decisions. And I appreciate the service of each and every board member who has to make these decisions and weigh everything at play. But again, with a proposed stipulation, the licensee agrees to the terms and they waive their right to seek reconsideration or appeal. So they can't have a change of heart once they really start thinking about the onerousness of being on probation. They have agreed to it, and if the board adopts it, that's it. So along with that, the board is avoiding risk. It's assured that the discipline is being imposed, and it's avoiding the risk of a less desirable outcome. And sometimes this means that the board adopts, for example, a letter of reprimand, because the concern is that if it goes to hearing, there is a risk of no discipline being imposed if the ALJ says there's insufficient evidence to support the charges. And if that's the case, the accusation falls off the physician's profile. There is no public record of discipline. And that's on the physician's profile. Yes, someone can ask to see if there was ever an accusation filed, and accusations that are filed and dismissed remain part of the public record. But the law does not permit the board to post that on the physician's profile. With a public reprimand, it is posted on the physician's profile for 10 years and remains part of their record indefinitely. With order of probation, that remains on the physician's profile indefinitely. And so a stipulation for probation will be there for the public to see as long as, well, again, indefinitely. So these are things that board members must weigh. And the fact, like I said before, it's the discipline is imposed sooner, not a year or longer from this point. And the reality is stipulations that are appropriate, not just any stipulation, but appropriate stipulations, they should be resolved, if they are appropriate, through that tool, because it preserves time and resources for cases that must go to hearing. And I want to give a case example because just to illustrate this, if you'll indulge me for that, Ms. Lawson, is that okay? Are we okay on time?
Yes,
okay.
Please. I think so.
Okay. So this is a licensing case, but they often have similar issues, but I think this illustrates what I'm talking about. So in this case, Dr. A applied for a license, and it was determined by senior staff that he did not qualify for a full and unrestricted license due to a recent conviction for driving while impaired and false statements reported to the Betty Ford Center and the medical board. So although Betty Ford concluded that Dr. A did not meet the criteria for a substance use disorder diagnosis and found that he was fit to practice, the evaluators determined him to be defensive and evasive and found that he did not accurately report his last consumption of alcohol. Dr. A verbally amended his written statement to Betty Ford following a positive biological fluid test. He submitted an official document to the board on April 7th, 2011, under penalty of perjury, indicating that he had a California driver's license when he was not actually licensed in California until May 14th. Because of his compromised integrity and concerns regarding his recent conviction, he was offered a 5-year probationary license requiring him to abstain from using alcohol and controlled substances, random biological fluid testing, perform community service, take an ethics course, and then standard terms and conditions. Dr. A agreed to the terms, and the board was presented with the proposed stipulation. The board rejected the proposed stipulation and wanted an outright denial of his application for licensure. Dr. A demanded a hearing, and a statement of issues was filed. That's the charging document in licensing cases. And the administrative law judge found that he testified in a sincere and forthcoming manner, consistent with credibility. He has learned tremendous lessons from the whole experience. And the administrative law judge proposed a free and clear license. So that proposed decision came back to the board non-adopted it, and gave him 3 years probation, required him to take an ethics course, and then the standard terms and conditions. So no abstain from alcohol or controlled substance, no biological fluid testing. And the board was hamstrung by the findings of fact from the administrative law judge, because the board's required to give those findings great weight. And so this is what board members must weigh, and it's a difficult job. And again, I appreciate the service that each of you performs, and I'm happy to answer any questions.
May I speak, Ms. Lawson?
Yes, please, Dr. Kraft.
Ms. Webb, thank you so much for this presentation. Having served on panel B for 7.5 years, these are all of the gray zones that we have to consider in each and every case. And it's been somewhat frustrating that we haven't been adequate in communicating this to the public. We have a board member and rising sentiment amongst the public that we're being deficient and we're not protecting the public because we're not following the guidelines. And we have a manual of model disciplinary orders and guidelines on our website dated from 2016. And except for page 1, the remaining 28 pages are in black and white. But the background of your slides is in gray. And indeed, there's a lot of gray in every panel meeting, and there's a lot of gray in coming to a decision on every case. And I fear that the information that you've presented today will quickly be forgotten or ignored by the public. So I would appreciate and suggest to staff consideration of an update of our 2016 edition of Model Disciplinary Guidelines, which is on our website, to include all of the information that you have provided today, so that any member of the public can access our website and see all of the considerations that go into these difficult decisions that our board makes, so that we can stop being held to the black and white standard of what's dictated by the guidelines, and have the public understand that this is a far more difficult and nuanced process. Thank you, Ms. Webb.
Dr. Hawkins, may I speak?
Please, Dr. Hawkins.
Thank you. Carrie, thank you very much for some clarity despite the complexity of what we deal with on the panels. Howard has already, by referring to one of my questions, when was this, when was it just last updated, 2016? So when you said in one of your early slides that guidelines are adopted and modified through regulation, that this is a public process, what do you mean by this being a public process?
The proposed changes to the guidelines have to be done in essentially track changes so that people can see what is being proposed. This has to come to the board for the board to consider the language, just like we're going to do later on today. And the board has to adopt the suggested language or make changes to it. And then that goes through a full rulemaking process. So it's subject to public comment. People can ask for a hearing on it. And typically for something like disciplinary guidelines, we would schedule a hearing on it so that input from stakeholders is considered. And then for public comments that are negative, the board must respond to those in the final statement of reasons about why this language should still go forward. Or the board can consider those public comments and say, yes, we need to change this part or that part. If that change is made, it has to go out again for public comment. So the first round of public comments is for 45 days. The second round on modified language would be for 15 days. And those notices are on our website, and it's blasted out to people who subscribe to our regulations notice. So that's what I mean by it being a public process.
This sounds very important, and it should require some transparency. Thank you very much, Carrie.
Yes.
Additional comments or questions from board members?
Yeah, this is Ryan Brooks.
Mr. Brooks, please.
Has the department or DCA ever conducted an outreach program where we actually sit down for a day and go through cases, not active cases, of course, with the public, so they get a better sense of some of the challenges, the nuances that we as board members go through? Has that ever happened?
It's a good question, and not that I am aware of. I've been with the board for over 8 years. I don't recall anything like that, but I have given this training before, and I think that that's an important point, because criticisms about the level of discipline, I can understand it from the public's perspective, but I also understand that it would be even potentially more dissatisfying if the case was dismissed outright or even less discipline ultimately imposed. So I think that's a very interesting suggestion / question, Mr. Brooks.
I mean, I think it'd just be, great for the public to actually sit down. We can have a full day workshop and provide some mock, cases, obviously, and walk them through the process, right? You can see it, you can hear it, you can touch it. That goes, I think, a lot further on, building that trust. They still may not agree with you, and that's okay, but at least they'll have the experience and the opportunity to see what it's like on the inside. Thank you.
Mr. Brooks,
Thank you for that.
That's a great suggestion, and perhaps for one of our future public stakeholder quarterly meetings that we're going to hold, we could use at least a portion of that, or if not all of it, for that purpose. Are there additional questions or comments from board members? Ms. Lubiano? Yeah, Doctor, I'll get to you next. Dr. Yep and Dr.
Thank you. Thanks, Carrie, for the presentation. I especially like how you include the B&P codes that relate to each section. I wanted to pick up on a point that you said that I think that's important, in that that one simple departure is not enough. And so for, as a reminder and perhaps to also help the public, can you explain the difference between a simple departure and an extreme departure, please?
An extreme departure would be gross negligence. And so this would be an event that should never happen. And one act of gross negligence can be grounds for disciplinary action. Repeated negligent acts fall below that level. Where that line is subject to expert review. And it's, that's part of the challenge, is describing where something falls on that continuum. But that's why cases go to expert review, and that the expert describes whether something falls within an extreme departure or a simple departure. And you will get maybe the board's expert saying that it's an extreme departure, and then the respondent's expert will say that it's a simple departure, and the administrative law judge, if it goes to hearing, will have to weigh that and make that determination. And that is part of the risk that the DAGs are describing often in their memos, so that the board can weigh that as to whether this proposed stipulation is appropriate to ensure that discipline is imposed.
Thank you. And just a quick follow-up. So is it possible then that there could be one simple departure and a patient has, experienced, harm for the rest of their lives, but because there's just one,
Right.
It doesn't rise to that level that we're able to take an action. Is that correct?
Yes, that's
Is that
correct.
possible?
And I think you just raised an excellent point, Ms. Lubiano, about patient harm. It's very difficult if there is a death or serious bodily injury, or frankly, any injury whatsoever, to accept that a public reprimand or a probationary term that's less than the disciplinary guidelines is acceptable. But the board cannot start with the fact that there was a death or patient harm and then decide what the appropriate level of discipline is. That's not how the system works, and would be very detrimental. But I know how dissatisfying that is to the public, especially people who have been harmed or their loved one has been harmed. And I completely understand that. The flip side is that the board does not require there to be harm in order to impose discipline. The point is impose discipline so that there is not future harm or worse harm. You want to correct it right away. And so the fact that there was no patient harm is not a good reason to not impose discipline.
Thank you. Thank you very much.
Thank you, Ms. Lubiano. Dr. Yep.
Hi, thank you. First suggestion is that I think the presentation is good. We can in a video format that Karen and staff can make a video and put on the site so anybody can see it, public or licensee, to explain the process. Second is to, as you suggest, the stakeholder meeting, and I think we should prioritize the guideline, which is kind of outdated, and we should hear from the public, which actually include public consumer licensee, the ALJ and DAC to be there so that they can hear the public what are the guidelines about and how behind we are and what need to be updated. The third, I was going to make at the end of the meeting about what's the agenda in the future is how feasible for the panel member to meet even online now, which is actually quite inexpensive, once a month, once a quarter. They may help to speed up the process of these decisions. They may help to shorten the caseload, and I think it's a service to public and also licensee too. Thank you.
Thank you, Dr. Yep.
Okay.
Ms. Lawson, Dr. GnanaDev.
Yeah, I think, just a minute, I think Dr. Lewis had a comment next, if I remember who I had in the queue.
Yes, I did. Carrie, a long overdue primer on the disciplinary guidelines. I've been on the panel A for almost 8 years, and this is the first time I've heard such a presentation. Even though we had board training, it needs to constantly be refreshed in our minds, whether you're a seasoned board member or a brand new board member. So I applaud you for putting this presentation together, and I look forward to referencing it frequently before our panel meetings. Thank you very much.
Thank you, Dr. GnanaDev.
Thank you. So I just want to, Kerry, thanks for the presentation. I don't even want to say how long I've been doing these things. So if you look at the proposed stipulations, they're done by DACs with the help of our staff. And these people are experienced, they're attorneys, they know what they are really looking at. And majority of the time we approve them. And if we think there is some way we can make it better, we hold them. Only 2 people need to hold. And then it comes for a discussion. And in the discussion, majority of the time in the panels, we agree in the end. Occasionally one abstain or dissension. So there is a good process what goes through. So we can't blame either the board or the staff, because the time it comes to the board is at the final stage of the confirmation of the discipline, not during the entire other process. And the ALJs, often when I look at it, ALJs are they are the judges, so they know the legal system. So they actually, I have more problems with the ALJ decisions for being too lenient often than what comes out of the stipulation. So it's a very complex process. Last one, I mean, I'm triple boarded surgeon. I've been in practice 40 years. Medicine and the teacher, training students and residents. Medicine is not an exact science. Medicine is part science, part art. And a bad result is not an automatic indication for a bad performance. There are certain level of complications. You might do nothing about with a small wound, see the patient in the ER, next day or 2 days later, patient comes back with the tetanus, or patient comes back with necrotizing fasciitis. So these are the ones which is which is a tough issue, and it's difficult. I do totally understand public's opinion because they saw a bad result and they expect doctor to be punished. Our job is protection. If there is a bad result, the doctor will be disciplined. But protection of the future, example, 2 drunk drivings, no hurt, no damage to anyone. But we put them on 5-year or 7-year probation because we want to prevent what that person can do if he continues to do so. So I think it's okay. Self-criticism of the board is nothing wrong with it. We should never have a group think, but keep in mind what our job is. That is the protection of the public. And Kerry, thank you so much.
Thank you.
Thank you, Dr. GnanaDev. Are there additional questions
Dr.
or
Mahmood?
comments from board members?
Can I
We'll start with Dr. Mahmood. Yeah.
Please.
I have kind of thank you very much. Different question. It was a really great presentation. When we have some complicated cases which require urgent attention and delaying the process might be harmful to the public and that might be making a negative impact on board, is there any possibility that before the Department of Justice make the stipulation or whatever the decision they make send to the board, they get some kind of idea from the board on those particular cases, that what would be your thought process, so that it goes there, they bring it up to board, 3 months later comes to board rejects it, goes back, take another year before we come to something. Is there any way, are there any legal hindrance for them to come to the board before they go and make a decision, that what will be the board's thought process? And I'm talking about severe cases.
That is not part of the process, but it sounds like you may be talking about cases where an interim suspension order is warranted. Those don't come to the board members. Those go to the administrative law judges in cases where there can be immediate risk of harm to the public. And the issue with those is that the case has to be worked up enough to the point where within 30 days after the interim suspension order is imposed, the DAG is ready to go to hearing. And so there has to be a certain amount of investigation so that it's almost complete and ready to go before that interim suspension order is obtained. Otherwise, there's a risk that the hearing may not be successful, which would be a terrible result in a serious case. Sometimes these can be imposed through stipulation, which again, that's the value of stipulation. You can sometimes get agreements and conditions and terms that you may not be able to get or likely won't get if you ask an administrative law judge to impose it. So there is a tool for the serious cases that you're talking about, Dr. Mahmood, but it doesn't come to the board.
Yeah.
Additional comments or questions from board members before we go to the public?
Yes, Christina, this is Tita.
Mr. Hawkins, please.
As everyone knows, I'm the one that has probably created a lot of issues around this. And it's kind of interesting listening to my fellow board members, because I can put I can link it up, because I have spent more time in this than I think anyone else would even think about spending time on it. And so here's my assessment. If we know, I'm hearing comments like, we haven't had this training in 8 years, and it's so complex, it's so difficult. It's not that difficult, honestly. It's complex, yes, absolutely. But, and I can just give an example, because I'm going to use examples to make the points here today. That when sexual misconduct cases, prior to the Federation stepping in and creating model guidelines for how it happens, Those decisions on this board were all over the place, right? And Kerry can disagree as when we go and, and we can have not a deep discussion, but once those model guidelines were in place, the decisions kind of lined up and a standard was established, right? There's standards for the uniform standards. There's standards, and to a varying degree in the substance over prescribing domain. There's on the different levels of care. Different experts have different opinions on that. But for the most part, we can find a uniform standard on it. Here's my first point. When we talk about punishment in the board, in this particular board, what immediately becomes apparent that if we go over 3 years, if the guideline says 5 years, that we're punishing the respondent, is punishing the doctor. And that's fundamentally false. The deal, and here's the point, if you apply the guidelines, you actually effectively have a respondent enter into a rehabilitation program, because a big part of rehabilitation is oversight. What makes Betty Ford Clinic and all these other places so effective is the level of their oversight, the quality of who is overseeing them, right? So if we shorten the period and to 3 years for when we deviate from the standards, which everybody says it's not black and white, but that probation period is the only the only element in the disciplinary guidelines that people actually notice. I agree with Kerry, and that needs to be expanded and explained to the public, because that's where we can handle some of the complexity, right? But that's the first step. I'm gonna just mention in other boards where the standard is of the same level, and people apply the full disciplinary guidelines and make the mitigation in an effective way, those boards act in alignment. And those boards do not have similar issues, because the minute you deviate from the guidelines, you're going to find yourself in no man's land. We are in no man's land. I'm going to ask Kerry, and she can answer that when I'm done speaking, whether she believes that we are actually applying the did this board establish uniformity, consistency, and fairness in our decisions, and just for the last year? And my opinion, and statistically I can prove that, is absolutely no. So if everybody is self-congratulating because we're doing such a great job, I'm going to let you pause for a second, because I'm going to just line out exactly how cases are going to go, right? This board is going to decide from today on, from every day forward, that a public reprimand will be issued every year, like it has for the last 13, 15, 16 years, 35% of the time. Those cases that will be publicly reprimanded will be all over the place. It will not be two simple departures with one patient. It will be beds that we couldn't prove, whatever. But here's an interesting thing that the board needs to know. That in about 38% of the cases, when we issue a public letter of reprimand, it touches a subject called expert issues. The expert that we have isn't good enough. The expert is up and down in their opinion and all of it. But in those rare cases, and they do exist, that the expert never moved from his position, we will reject that expert opinion, thus further compromising the integrity of our own disciplinary process. Another point, and this is a point that we all talked about, and it's a point that challenged my ethical consideration, is how can this board, how can we, and I know it's a practice, I've been told, that as a doctor can have an expert, we can have an expert, but that doctor's expert is also a board expert. And we say that that doctor's expert will be impartial, so we can't take his opinion. I want you to go check the statistics on how many times we have rejected our own in favor of the doctor's expert. Now, there's many reasons for that, but it's always interesting to understand how many times we do a thing, because the statistics show you an unconscious pattern, how you don't think, how it's automatic. A lot of what we do on this board is automatic. It's rubber stamping. Every decision. When I'm pointing to a statistic that says that 99% of the time we follow the DAG memo, right? Then immediately I want to look at the DAG memo. Today I learned something, that the standard again for a DAG memo is lower than the standard in terms of it's not publicly disclosed. So in that private attorney privilege document, a lot can be said because it's protected, right? I have probably on this board held more cases than everyone. I can probably safely say that. And I've held those cases because I have deep concerns about the tone that is hugely biased. And I can actually bring you closer to a real experience. And the real experience is, yesterday I was sitting in hearing and a DAG came before us and spoke for 13.5 minutes defending a doctor. It was so unbelievable. She was unbelievable. And I was sitting there thinking to myself, the talent on this attorney, if only that talent was employed in the protection of the public, over and above to protect the doctors. Now that's the job. I learned something. You see, when I'm watching this, I'm seeing less of an intentional motive behind it. I see a lot of unconscious. I see a lot of things that we've just accepted. I see a lot of the stuff that I used to see when you encounter a system that has an implicit bias that's built to protect a certain group of people. And coming from apartheid South Africa, I'm very familiar with that system. And it is borne out by the outcomes. You know, when I'm quoting a number and saying that only 1.2% of the entire complaints process from the total amount of complaints will actually result in probation on this board. And that doesn't alarm us. We 1%ers. So 1%ers is not protecting the public, right? We can establish what standard that would be. That's a way forward to have a measurable standard. But 1% is absolutely, absolutely not okay. Another point that I'm going to make is when I have a lot of issues, like I said, with the DAG memo. It's not just the tone of it. It is a legal document that creates a legal veil that I have serious, and I don't want to keep raising the same point, but I have serious ethical concerns about that. I have come across some of those documents where what is written in there is manipulated to give us a certain opinion. Now the board is a ready audience. I heard one of my colleagues say, yeah, they know. If they know, why bother having us on this panel? If we rubber stamp 99% of their opinions, what's the point? Another point is holding a case in this board means nothing. Absolutely nothing. I can actually attest to that. And why does it mean nothing? Because at the end of the day, we will not have the votes. It has changed one mind in my experience here, where something that happened recently was inspiring for me. Because if you go through this process and you see so many cases, And this is for my new board members. How you see a case is when you start feeling that sense like this is not fair, right? Your fairness for a red flag goes up. And it's not fair because, again, the public is marginalized and marginalized. And the great dagger that I referred to yesterday, she made a great point. She said, you know, I asked about the public input, and Carrie pointed this out. And this is for learning for the future. And she says the public is not relevant here. They are affected, but they're not relevant. So we preach public protection, but they're actually irrelevant. And so they become irrelevant in the statistics. Because what we need to focus on, and here I agree with Kerry, what we focus on is the legal process. And the legal process is what gets the cases done. The legal process is what's getting the job and protects the board and all of it. What I'm just alluding to is that this is a bigger problem. This is much like the issues that they have in police racial injustice. It's exactly along the same line. And I'll tell you why. The disproportionate favor that the doctors enjoy when one of these cases come before us is what the public notices. And we can legally justify it, we can use our legal veil, but every day when we want to go out, and this is my last point, when we want to go out and build trust, if you don't build trust in the decisions that you make, we can have all the outreach that we want, we can have all the communications that we want, but we haven't moved the bar one bit. I'm suggesting that we look at these numbers and set measurable standards. And if laws have to change, please let us change those laws. If standards have to be moved, let us move those standards. I always feel like we are not even in control of this board, that somehow we are pawns in a bigger game. And I would like to understand from my fellow board members that has been on this board longer, how can we affect change and actually protect the public so we can show on paper that we're doing that? Because right now, this has just shown me we've got more work to do. This is not a trashing moment that I want to have with my fellow board members. I recognize the problem. I see it way more clearly because I've been in these discussions. My concern ultimately is that people that are really living with this, they get to relive it every time when they call into this board and they see another thing happening to somebody else. If something happens to a person, the one thing that makes them whole again is to know that they've made a difference of preventing it from helping somebody else. We've done this for a while. We are living in California, USA. The smartest people on the planet live here. And you,
Mr. Watkins, can I ask you how much longer you have in your remarks? I'm trying to, I've given you 15 minutes so far.
Oh, I apologize for the time. But we're living in the smartest place with the smartest people. And you tell me we cannot resolve this puzzle. I think we can. And I want to thank everybody and Kerry for the presentation.
Ms. Lawson.
Thank you, Mr. Watkins. Yes?
I would like to make a point that DAGs during closed session, they are obligated to let the members know what is likely to be heard at hearing with the administrative law judges. That is not the same as defending the doctor. It is part of the consideration that board members must take into account what an administrative law judge is likely to hear and how that can impact the decision. with regard to patient statements, the legislature has considered this, and the board must not receive patient statements. This is per Business and Professions Code 2330 as part of its pending decisions. Because again, whether there's patient harm or not, the decision must be based on whether that physician violated the Medical Practice Act. And I have much appreciation for Mr. Watkins and his role on the board, but I do want to make sure that those things are clear to the members. Thank you.
Ms. Lawson, can I speak for that, Dr. Mahmood?
Board member, Dr. Mahmood, I'd like to take public comments. Can we go to public comment and then come back to board members, especially ones who've made comments?
Okay, that's fine. That's no problem.
Thank you.
Thank you.
I'd like to go to public comment now. I know that we've got folks in the queue who'd like to speak.
I just opened the Q&A window and the hand raising functionality for anyone who'd like to make a public comment. Please indicate so. The first up here, we have Hannah Ree. Hannah, are you there?
Yes, hello, Hannah Ree with Black Patients Matter. So, Mr. Watkins, you are spot on. You're absolutely correct. So we are all behind you. So the other thing I realized from listening to Ms. Webb speak was that so there is a large amount of corruption at the ALJ. It's very simple. I will send you evidence. First and foremost is that I had paid over $6,000 for official copies of my 5-day hearing, official transcripts of the hearing, paid over $6,000. And when I received them, 3 of the 5 days, the transcripts were altered. My attorney and I looked at them and they did not reflect what was stated in the testimony at the time of the hearing. And coincidentally, those 3 pages, those 3 days that were altered, the court reporter did not sign and certify those copies. So the ALJ had given to me altered and non-official certified copies, but the other 2 days of my hearing were signed and certified, and coincidentally, those there was no problems with those transcripts. So myself and others are working to fix the corruption at ALJ. I mean, certainly, if we have found, Mr. Prasifka, if we have found that there are a large amount of money missing from the HQIU, certainly it would not be a stretch to see that there's a large amount of corruption at the ALJ. And number 2, in Ms. Webb's comment about, if a case goes in front of the ALJ and she finds something and it could be dismissed, let it be very clear to everyone here that the ALJ has never dismissed a case. So what does that mean? Well, I guess that means, in my opinion, it's consistent with the corruption. How can a judge never dismiss a case? So along my other comment is that it's difficult that for myself with no claims, no drug use, no DUIs, nothing has been revoked and been told that I'm non-rehabilitatable. Very sad to see. I am that example of someone who's been corrupted upon. So I thank you for your time, Board. Thank you, Mr. Watkins.
Thank you for your public comment. Next up, we have Eric Andrews. Eric, are you there?
Yes, I am. Can you hear me?
Yes, we can.
Okay. I have about 10 pages of notes and about 50 Post-its that I put on, so I'm going to talk really fast. You'll just cut me off when I'm done. Howard, thanks for insinuating that the public is stupid and don't understand. Doctors are known for blaming the patient, so that makes perfect sense. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the public. Carrie is paid big bucks to protect the board, not the She's biased. You need to consider that when she makes these presentations. You can use, Ryan, you can use my closed campaigns to figure out why they were closed. Use them as a case study. You'll be interested in that. Carrie misled you when she said you should not consider harm. The law says that certain cases like death, sexual assault, need to get higher consideration and move to the top of the queue. So again, she's misleading. We can prove that cases are not given titles of gross negligence just so it's easier to process and get less discipline. We can see that before it gets to the accusation point at all, they're definitely considering what kind of things to associate with them, so there's less work and the doctor gets less punishment. Cases are being manipulated before they're even written. Carrie thinks that if she reads this dry information, it excuses the board from allowing doctors to get off easy for harming and killing patients and violating your order to protect us. That in turn causes harm by this board when victims and families have to suffer the consequences of this board's actions and inactions. The guidelines clearly aren't working, so talking about them as though they're the Holy Bible is ridiculous. Oh God, I can't read my notes. I'm sorry, guys. This presentation was more about you skirting the laws and your mission in order to do less work and protect the doctors that pay your salaries. If the board were to follow these more closely, they'd be broke in a week. Just because Carrie and the others say public protection is paramount doesn't in any sense mean that that's what's really happening in real life. Taking steps to correct is only a small portion of the equation in figuring out whether rehabilitation should take place. We're seeing the board give far too many lenient disciplines only to have the doctors reoffend. That's not patient protection. The board not being able to punish is just semantics. Ask any doctor you've revoked their license without good cause or placed on too much probation in retaliation for something you didn't like that they did. Ask Dr. Hannah Ree if she didn't feel that was punishment. You do punish. You just change the words you use to make yourselves look better. We've seen disciplines. We've seen disciplines where deviation from the guidelines were not adequately explained. So that doesn't happen all the time. How convenient that it says that they aren't binding standards. There's little point to them if they aren't. The conflicts with the next page say, oh shoot, I can't read my notes. I wrote so fast. I'm sorry, guys. Okay, that's it. I actually have to go do an inspection on my new house. I'm not going to be able to stay for the rest of the meeting, so I'll see you guys next time. Bye.
Thank you for your public comment. Next up, we have Virginia Farr. Virginia, are you there?
Hi. Listening to this is so concerning when you hear about mothers who lay bleeding to death for 10 hours and nothing is done. Probation is not good enough for that. Hearing Mrs. Lauren's story over and over, how she was assaulted under anesthesia and nothing was done, it's heart-wrenching and it's not good enough. I'm a member of public and I do not feel safe going to the doctor. I have been harmed so many times, but I would be thrown into this yellow zone of 10,000 plus people cases that nothing gets done about it. And thus I've lost $1 million. I've crashed my nervous system. I've had 20 injections for pain. It couldn't sit for 3 years. And nothing would be done because of your laws. And on top of that, there's this deny and defend where my medical records haven't been accurate since 2010. You could not tell what happened to me if you look at my medical records at John Muir Health. There's absolutely no way to know my medical history. And so these laws you have is not protecting the public. I am the public. I am not protected. 100% not protected. And I'm terrified to go to the doctor because last time it cost me $5,000 for a $45 test that they missed. And guess what? They falsified their records. So you'll never hear about that case. You also never hear about when I was sexually abused as a chiropractor after all this. And you also not hear about the person that says he's a doctor and that's not, because I don't trust you guys doing your job. So I don't know. I just don't feel protected at all. And I'll likely die young because of the medical system in California. End the conversation. Thanks. Please do something about it. And remember those 30 people that are dying today or harmed, please keep a moment of silence for them because they're still being harmed while we go through this. Thank you.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yes, I am. Can you hear me?
Yes, we can. Go ahead.
Thank you. First of all, I really want to thank TJ for giving the public, like myself, a voice. And it is so important. And I just want everyone to know how important that is. And thank you to Ms. Farr, who just referenced my case. There is no way that what this board did was fair. Okay, in my case, if you're minimizing this in any way, you're not doing your job. Saul Berger violently assaulted me while I was under anesthesia. This was not a medical error. This was not one deviation. This was a never event over and over. He took an 11 blade. He stabbed me into my kneecaps. I was there for a breast reduction. He stabbed me into my hamstrings over and over and over and over. He wasn't done. He stabbed me into my iliotibial bands over and over and over. He stabbed me into my butt, all for no reason. Over and over and over and over again. You know what? My entire butt is gone. Why? You will not find anywhere, even on his totally, I'm sorry, I'll bring my voice down. I get obviously upset and I have a right to. Even on his notes are complete lies and omissions, starting with my breast size. And I was there for what was a needed breast reduction. And I was at 32G and a tiny petite body, a 25 waist. I was extremely athletic. So I had these big breasts on a little body. And he wrote that I was a 32D, which is what I told him I didn't want to be any smaller than afterwards. And I can't tell you for sure, but I have a supposition that he wrote that because he took so much out of my breast. It's not just this liposuction. What Berger did to me, this is a criminal. This is a guy that should be in jail. And if you've got a medical board that can't deal with that, what I've been asking for years now is have a case like this be a criminal case. Now, someone can be sexually assaulted and you'll take it more seriously. If someone had assaulted me like this on the street, there's not, what'd you say, 30 seconds? There's not a person that would say, oh, we're going to rehabilitate them and put them right back into business. And there have been other people harmed that I believe that claim harm from him before and after me, and also with Dubrow, who came and lied at my trial. Now, without talking to me and my witnesses, my doctors, and just talking to, look, I know Tom McAndrews, Berger's lawyer. He staged a totally corrupt cover-up. I was there, slanderous, and to do this to victims of harm. Okay, yes, thank you. Let me just gather my thoughts for 1 minute and I'll conclude. Everything needs to be changed because you're making excuses, you're minimizing, like TJ said, it does make it wrong. I mean, it does re-victimize us every time we hear this. Police should have been involved. Carrie, what's her name, Delp, said that I should take my case of assault to law enforcement, and law enforcement, which I had already been to.
Thanks for your public comment. Next up, we have Marion Hollingsworth. Marion, are you there?
Yes, I am.
Please go ahead.
Okay, thank you. Good morning. My name is Marion Hollingsworth. Regarding the disciplinary guidelines, I read the decisions from the medical board, and I can tell you that these guidelines of yours are rarely followed. The bottom line is that you are settling. Instead of doing a good job, you are doing a job that's just good enough, like Ms. Webb just said you did. Here are some recent cases where the guidelines are not followed. Dr. David Batat of Lakeport was found responsible for the deaths of 4 patients, 2 from overdoses with the Death Certificate Project, 2 from failure to diagnose. What was his discipline? Just 3 years probation, even though the guidelines recommend a minimum of 5 years for each case. Because he just got 3 years, Dr. Patat won't have to notify his patients under SB 1448, and he can apply for early termination in just 1 year. So his discipline was considered good enough for public safety. Dr. Tanya Harris-Stanza was found responsible for a failed VBAC delivery. You found she failed to monitor the baby and arrange for an emergency surgical team on standby. The mother's uterus ruptured and the baby was dead by the time a C-section was attempted. Her accusation said repeated acts of negligence instead of gross negligence. Now, the guidelines do say that for repeated acts of negligence with one patient, a reprimand may, in appropriate circumstances, be ordered. So that's what this doctor was given. For the board, a reprimand was good enough for one dead baby. As I mentioned yesterday, Dr. R.J. Naeem was given 4 years probation after Kira Johnson bled to death and 2 other patients coded in the OR after botched C-sections. 3 other patients also had bleeding issues. Today's presentation said the guidelines must be consulted for each violation, yet Naeem's discipline was deemed good enough. And then there is Dr. Narayana Ambadi of Fresno, who is found responsible for unprofessional conduct instead of sexual misconduct with 2 colleagues. For some reason, the repeated assaults on these 2 women where they could not defend themselves was not found to be sexual misconduct. The minimum recommended under guidelines is 5 years probation for unprofessional conduct. But Ambadi was just given a reprimand, so he won't have to notify patients. Again, not a good outcome for these women victims, just good enough. Why can't you consider public harm or death in your disciplines? It's the reason for these complaints. You give harsher disciplines for fraud than you do for public safety. It seems that with the board, public safety is only words.
30 seconds remain.
Thank you. It seems that with this board, public safety is only words on paper and not a serious consideration when a doctor's career is threatened. It's like the disciplinary guidelines don't matter because you will do what you want anyway. So basically, this medical board doesn't aspire to excellence in its disciplinary process, but rather you seem happy to just settle for what is good enough. Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat Ramos. Michelle, are you there?
Yes, I am. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I became a patient advocate when my husband-to-be, Lloyd Montserrat, who was a political leader in the city of Los Angeles and throughout the state of California, died needlessly at the hands of a substance-abusing physician. You found his case not worthy of investigation, and it was dismissed at the Central Complaint Unit. That is why I am so passionate in my work and why I've stayed to advocate with you for the past 15 years. I now work with families across the state of California to guide them through this complicated process of yours and to educate Californians of medical negligence. Since the majority of decisions are stipulated decisions, and in stipulated decisions, the board does not have to reveal why you've deviated from the disciplinary guidelines, we recommend that you move to reveal the reason why you've deviated from the disciplinary guidelines in stipulated decisions as you do in proposed decisions. You can make this change through legislation. At least then, families will understand why their deaths and lifelong harm did not meet the disciplinary standards and why the physician discipline was so minimal when their death and loss is permanent and not minimal. Also, those cases that get dismissed for insufficient evidence, late stage in the enforcement process, or at the AG's office, that the board allowed the family to review the DAG memo so they can understand why their family member's death or lifelong harm did not warrant discipline or an action to protect consumers. If you offer a stipulated decision because you feel that you may not get discipline from a hearing, then I recommend that you not allow a doctor on a stipulated decision to be able to file for early termination of probation. For true consumer protection, there has to be some protection set in for the consumer. There is due process for doctors, but Californians deserve some due process in this enforcement process as well. Thank you.
Thank you for your public comment. At this time, Ms. Lawson, I don't see any other requests in queue.
Thank you, Sean. We'll bring it back to the board. Are there any, Dr. Mahmood, I know you wanted to speak before I went to public comment. Would you like the first opportunity here?
Yes, so I was following up, TJ, and TJ, I really envy your courage bringing it up. There are a couple of things I just want to make sure. Our goal over here is not to please anybody. Our goal here is not to take any sides. Our goal is 100% protection of the public. And our decisions and our review should be just fair, not keeping in mind that every case comes that we have to prosecute and punish, but we have to be very fair, unbiased, and whatever the negligence or ignorance or crime has been done, that case should be punished by that. And to monitor that process, I think we could put some cases for audit and see if there was any deviation done on that. Instead of just putting the whole board in a situation where it gives the impression that board is in favor of doctors. Board is not in favor of the doctors. And I'm physician, I'm practicing physician, and I literally every single case I read for 4 or 5 times. And I think I'm one of the, on the panel B, I'm one of the most frequently person who's holding the cases for discussion. Purpose of that is to get more inquiry, to get more information so that the decision is right and decision is learned, so that public gets what we are supposed to give them, and we are fighting and we are their voice, and we make sure that not only everybody is safe and secure, but quality of healthcare in California stays on the top where it is. So I think we need to bring this out, and I think there should be some kind of more reach out. And as you have already probably having more meetings with stakeholders would probably solve this problem. And we cannot comment about the cases which do not come to the medical board. There are several cases which are sorted before that, and maybe there should be some audit on that, that how many letters of reprimand went there and how many were justified, and how people were doing after that, sending their letters, and people were repeatedly abusing their powers and kind of stuff. But yes, transparency, justice, and fairness to people, all the parties should be our goal. And that's what I think is always in my mind, and I'm pretty sure everybody's mind. I just wanted to bring this up openly. Some people might not like this on the other side, but I just want to be honest and fair and truthful. That's what I'm doing, because I'm not doing for any vested interest. I'm just doing it to serve the people of California.
And thank you, Dr. Mahmood. Additional comments from the public? Ms. Lubiano? Excuse me, from the board members, not the public.
Sorry,
Lubiano?
I respond to Dr. Mahmood. Dr. Mahmood?
Okay, Mr. Watkins?
Yes, I think that to put some of these steps up for a review by an independent party would help maybe restore some of the trust, and will satisfy some of the, by an independent party could establish what could be better practices. And I think that would be a reasonable solution to address some of the issues. Thank you.
I agree.
Ms. Lubiano, I know you were waiting.
Thank you. I won't take too long just to pick up on what Mr. Watkins has been saying. I think, so just for a little background, so I work in tech, and as many tech companies do, we look at data and we make decisions based on that data, do analytics on that data. So, feelings aside, I think we can all say that we feel that we're objective and we do our best when we look at these cases to make sure, we have public protection top of mind. But I would say, well, let the data speak for itself, and perhaps that is a starting place to prevent any kind of impasse. And when we get some more data about the stipulations or the proposed decisions, and whether by practice we actually are following the guidelines consistently, I think that would be a good place for us to start. Thank you.
Thanks, Ms. Lubiano. Do other members of the board wish to comment or have additional questions? Mr. Brooks?
Yeah, I'd like to make a quick comment. First, I appreciate the public speakers today, because in that process, this is kind of what drives us. And I think we all have the passion and follow the same goal of public protection. I myself, I'm a data-driven person. It's kind of my passion is what I I think I do very well, but I want to be very cautious. I think, Mr. Watkins, passionate conversation about the data on whatever the standard deviation is from the guidelines is important to look at. But I think if we're going to take a look at that, let's look at also what the outcome is, because our outcomes are public protection. And I would love to see, like, if when we send someone to prison and they get out, what's the recidivism rate, right? Because that's the true public protection. And so I would love to see whatever those guidelines are. If it's 3 years, 4 years, you deviated 2% above, 2% below. I would love to look at the total population of the doctors and see what their recidivism rate is, because that tells, I think, a bigger story. That's the story of, is the public safe? And if the public is not safe, that means our process is flawed. But I don't think you can just look at a vacuum, the standard deviation between, 3.5 years, 4 years, or 5 years, which is important. I definitely want to look at that. But I think we need to take it to a different level, because that's where the public protection really comes into play. So, thank you.
Thank you, Mr. Brooks. Additional questions or comments?
Yeah, Ms. Lawson, I think I actually agree with Mr. Brooks that we should look at the recidivism rate and see what it is. I think that should tell us if we're doing something right or wrong.
Thank you. Ms. Campaverde, did you have a comment?
I did, thank you. I was just going to say very quickly, because I know this has been a robust conversation, that I think it's a very important conversation. And while I appreciate everyone's statements, I also think it's important we also hold ourselves and each other accountable behind closed doors and continue to have this conversation and hold ourselves to those standards, because again, our public statements here are important, but also when it comes down to our decision making, that's where we need to make sure also that we are living up to these.
Thank you. Are there additional comments before we move on to the next agenda item? All right, seeing none, we're going to move on to agenda item 14, which is an update from the Health Quality Investigation Unit. Is Ms. Nicholls with us?
Yes, can you hear me okay?
Yes.
Good morning, I am Deputy Chief Kathleen Nicholls, and I'll be giving an update on the division's Health Quality Investigation Unit. There are currently 7 investigator vacancies, which is a 9% investigator vacancy rate. We currently have 18 candidates in background. The reason why we have so many in background is we are anticipating more retirements through the end of the year, and we have several supervisor vacancies, which if filled internally will create new investigator vacancies. We continue to be very vigilant on conducting continuous hiring panels so we have an abundance of qualified candidates in background. We continue to provide specialized training for our investigative staff. In addition to all the training they receive in the Police Academy, HQIU provides ongoing specialized training for investigators. In March of 2021, we conducted specialized training on impairment investigations for all investigators. Also, last week started our mini academy for newly hired investigators. This was previously a 3-week classroom set of courses, which we have now converted into an online format. There were 18 investigators participating in the training last week, and there will be more training weeks in May, June, and July for the same group of investigators. Although it was converted to an online format, the training is still very interactive with a lot of participation. We also just had a 1.5-day statewide supervisor training and meeting in April of 2021. The training went over all aspects of supervising and monitoring our investigations with focus on problem solving and strategies for success for reducing timelines and more efficient processes. One of the areas identified as causing delays in our investigations is the ability to timely obtain certified medical records. HQIU has worked with medical board executive staff and the AG's office to devise a strategy to enforce the existing law 2225.5, which mandates that physicians provide certified medical records within 15 days of a request accompanied by the patient's authorization, and facilities must provide them in 15 days if they are electronic records and 30 days if they are paper records. We have revised our template letters to contain very clear language that late records and records without the required certifications will result in civil penalties being assessed. Going forward, when the records cannot be obtained by the deadline or the certifications are not submitted, HQIU will be requesting that the board open up a new case on the facility or the physician for the assessment of civil penalties. I'm a firm believer in not doing the same thing over and over again and expecting a different result. We need to be very open to change and an examination of all our processes to find the best way to reduce the overall time it takes to complete the process from the time the complaint is received until the ultimate discipline. Our implementation of the Expert Procurement Unit, EPU, has shown that these efficiency improvements result in lower caseloads for sworn staff with the goal of reducing timelines. I look forward to future discussions with board staff on examining some of our other processes, such as obtaining medical records and the types of cases handled by sworn and non-sworn staff, as we may be able to find further efficiencies to reduce timelines while still providing a great work product to protect consumers. In April, HQIU made a net reduction of 39 cases in the number of cases we have over 2 years old. We also made a net reduction of 43 cases in the number of cases over a year old. Per the graph that's in the board packet, 6B-13, we are currently still working on 179 cases over 2 years old. We continue to focus on the aged cases while trying to also make net reductions in the amount of pending investigations assigned to investigators. In April, we received 92 new investigations and completed 158. So we were able to see a good net reduction of pending workload. Another improvement we have made is regarding communicating the status of our aged cases. Board staff were always able to access the current case status of all HQIU investigations through Breeze. However, it's a large amount of cases to individually look up. In addition to monthly meetings with board staff and sharing Excel spreadsheets on the cases within 90 days of the statute of limitations, the DCA OIS team is currently working on a new report that will send to board staff automatically each month and contain the last 5 work note updates for all cases within 6 months of the statute of limitations. We want to be fully transparent with our workload and the status of each case for board review and discussion. I look forward to my continued meetings with board staff on how to improve our operations. And before I conclude my update, I just wanted to briefly make a point about the discussion of the disciplinary guidelines. In the sense, I think there's a distinction that needs to be made between acts of, say, a medical mistake or where there's medical skill, where a doctor can truly be rehabilitated by attending training or having a practice monitor, that's a lot different from a doctor who intentionally harms a patient by inappropriate touching, by falsifying medical records, by, dishonesty. And I completely agree that it is totally based on the evidence in the case and whether or not we can prove it. But when we can prove it, and we have found the evidence to prove dishonesty and all these other egregious violations, the only way to protect the public in those instances is revocation. A doctor still has the ability to come back in 3 years and present to the board why they're rehabilitated. And we know that these lengthy probation decisions in these egregious cases don't work because we are still getting cases in my unit that are referrals from the probation department. So we have doctors on probation we have cases on. We have doctors with prior discipline. So I would just urge you to pay really close attention to those cases where it's an intentional act and it's not a mistake. It's not a lack of medical skill, but when there's dishonesty involved, the truly measure to protect the public would be to revoke. So I throw that out for your consideration, and I'd be happy to answer any questions you have.
Thank you. Do any members of the board have questions on the update from HQIU? All right, seeing none, we'll open it up to the public.
Okay, I've gone ahead and
Sean,
opened
are you
up.
there?
Yeah, sorry. I've gone ahead and opened up the Q&A window and activated the raise hand feature. If anyone would like to make a public comment, please indicate so. First up, we have Hannah Ree. Hannah, are you there?
Yes, hello, Hannah Ree, Black Patients Matter. So, yes, thank you, Ms. Nicholls, for your comment about if there's any problems to address it to you or whatever you had stated. Now, remember, everyone, she is the person that's still in her position when Mr. Prasifka found a large amount of funds unaccounted for within the HQIU. Okay, so she's still in place. And so she's not someone who needs to go around stating that, you know, we're being too lenient on doctors and that sort of thing. Okay, and also the reason why her boss is no longer in power is because we had filed 2 federal civil rights lawsuits against the HQIU. Why? Because when you look at their website, they've since taken it down, and they award like a monthly award to their star employees. They never include a person of color. And let me tell you what, I have never seen a person of color in a leadership position within the HQIU. And also, when you hire new employees, Ms. Nicholls, I really strongly, we would like to see, we at Black Patients Matter would like you to see hire people that have worked in areas of racial equality, religious tolerance, and LBH, excuse me. But anyway, so inequality. This training does not work. Training is useless, all right? They have to have a work history in it. If they don't have work history, then they should not work for the HQIU. Thank you.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, are you there?
Yeah, hi. As far as revocation, and you know my case, that should have been the least that Saulberger got. And as far as data and going by data, when you're going by false data, you're going to not understand what's really going on. And when you're dealing with someone that mutilates someone and lies in their records, and the photos of me in court, they asked, is this you? I couldn't even answer that because the judge, who also was not, I can't think of the word, he wasn't ethical in my case. And he had told me that I need to just answer yes or no, or he threatened me with contempt of court. And I was thinking, well, how can I answer this? Because these are faked pictures of me. And there was a long time. And
can I ask you to focus, please, on,
yes, I will.
On the agenda item?
So, yes, and thank you for doing that. I do go off track. I apologize. But I believe that this was an intentional act by Saulberger. I tried to cancel the appointment the day before. His wife was his office manager, and they keep that from people. I had no idea that she was. I called and tried to cancel because my ride canceled, and she was furious at me. I came in the next morning she said, you'll lose everything. It's up to you. Don't come, you'll lose everything, and Health Net will never approve you again. Came in the next morning for the surgery, which I just thought, well, I'm going to have to do this and make the best of it. It's a breast reduction I need. And no, Berger didn't seem right to me. If I could go back in time, I would just have left. But I can't prove that. But the severity of what he did, if you put me as the poster child on a big billboard and said, this is what the medical board says is standard of care, I mean, you need to get the data from the harmed parties. I know, I've said this before, but I know who Tom McAndrews is. He lied in my case, and I have plenty of stuff. It's obvious. So I don't want to keep hearing how you're doing the right thing and self-congratulatory yourself with, oh, we're following the data. You can't follow false data, which is why a lot of us are saying that you need to have patient co-authored records. From here on out, we need to do patient-doctor relationships different because it's not working. And if you knew the number of people that I've connected with, thank you, you're patient with me. They're trying to do my best for all the men and women that I know that are, as Regina keeps saying, while we're talking, they're being harmed. And we really need to do something. We really need to do something. And yeah, we should look at my case again because it's absolute robbery of my civil rights and of the civil rights of people that go to these doctors after me. Thank you.
Thank you for your public comment. Next up, we have Virginia Farr. Virginia, are you there?
So again, I appreciate her mentioning the difference between medical harm and an error. The surgeon that harmed me, it was an error. I think he was just jaded and tired and couldn't hear. But the people after that harmed me by denying me care, denying me a pelvic ultrasound for 5 months, falsifying my records, turning a $20,000 error into $1 million error. And the original surgeon, I have no issue with because it was an accident. He said sorry after many years, and we talked and we hugged, and I have nothing about him. But doctors that intentionally harm people, they need to be held accountable at a different level. And these laws need to change so they're caught, and something, again, needs to be done about these medical records that we can co-author our medical records and have accurate medical records. Because once again, you can't tell my medical history. So that's it. Thank you.
Thank you for your public comment. At this time, that's all I see in queue.
Thank you. I will bring it back to the board. Do any board members have further questions or comments on the update from HQIU? All right, hearing none, we will move on to an update from the Department of Consumer Affairs. Sean, is Mr. Perez with us? I know that there was a timing issue as he was waiting for another board potentially.
Mr. President. Yeah, there we go.
Very good. Good morning, President Lawson and board members. I am Ryan Perez from the Office of Board and Bureau Relations at the Department of Consumer Affairs, and thank you for allowing me this opportunity to provide a department update to the board. First, I'd like to congratulate and welcome members Brooks and Rue. I'm happy to see that both of you have joined us today and late last night for that matter. While the medical board still has additional vacancies, I assure you that DCA and all of the appointing authorities share in the goal of a fully seated, diverse, and effective board. COVID-19 has affected every aspect of our work for more than a year now. And thank you to Mr. Prasifka and the board staff who have been working so very hard to maintain excellent customer service throughout these challenging times. DCA offices will remain open with preventative measures to safeguard the health and safety of our employees and visitors. Boards and bureaus are looking ahead to what changes can be made permanent for efficiency and employee well-being, such as telework and eliminating paper processes. I encourage all members and the public to visit DCA's COVID-19 website for updates and resources on vaccinator information, vaccine distribution, and more. DCA is receiving many questions about when and how boards will be able to meet again in person. And while I don't have a definitive answer for you today, I would like to offer some clarification. As you know, the ability of the board to meet remotely is tied to the governor's executive orders and the declared state of emergency. When these are lifted, the board will be required to follow all aspects of the Open Meeting Act, including publicly noticed and accessible locations. We do not yet know when this will happen or if any changes in the law will occur prior to that date. But DCA will do all it can to assist the boards and bureaus to transition safely and with enough time to plan for in-person meetings. Switching gears here, for current board members, 2021 is a mandatory sexual harassment prevention training year. That means all employees and board members are required to complete the training during this calendar year. As a reminder, newly appointed and reappointed board members are also required to attend board member orientation training within 1 year of appointment or reappointment. DCA is excited about the new and improved training, which has been updated based on board member feedback and requests. The next training will be held on June 23rd via WebEx. To register, please visit DCA's Board Member Resource Center located at dca.ca.gov. Additionally, the department will be conducting a budget and expenditure training for board staff on May 19th, starting at 9 a.m. And any questions related to this training can be directed to board staff at your will. Finally, I would like to update you on two exciting new initiatives launched by DCA for 2021 to enhance DCA services to all boards and bureaus. The first is an executive officer cabinet, and this group of board and bureau executives has been formed to maintain regular communication, provide feedback and information to DCA, and assist with special projects that impact all boards and bureaus. The group has met several times and is making progress on projects such as standardizing board reporting requirements. The second is the Enlighten Licensing Project. This work group is helping individual boards and bureaus streamline and make their licensing processes more effective and efficient by utilizing best practices, information technology solutions, and various other cost-saving measures. The work group has begun a deep dive into the licensing processes at the Board of Registered Nursing first, with process improvements being implemented in real time. We will continue to update you as these initiatives progress. As always, Board and Bureau Relations is here to help, and if there's anything that we can do to assist, please reach out. That concludes my presentation, and I will hand it back over to you, President Lawson.
Mr. Perez, thank you very much for that presentation. Board members, does anyone have any comments or questions for Mr. Perez? Right, hearing none. Sean, would you like to open up the public line, please?
Yes, let me get that open for you here. So the Q&A window and the hand-raising functionality have been activated again for anyone wishing to make a public comment. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, thank you so much. This is Hannah Ree from Black Patients Matter. First of all, I wanted to thank you so much for Miss Alejandra. I'm very concerned, board members, that you all are marginalizing her and her opinions, and that when she attempts to speak out during the board meetings, just as what had occurred earlier, that other board members have spoken over her. So I hope you are not marginalizing the Hispanic females on our board. That would be not right and not a good thing to do. So I would ask that you please give her the consideration you give everyone else. And then also for the DCA office, I just wanted to point out that it's nice to hear Mr. Perez speaking, but as we know, Kimberly Kirchmeier is the head of the DCA. She used to be the executive director with the medical board, but now we have Mr. Prasifka. And the reason why she had left the medical board is because we had filed a federal civil rights lawsuit, and she had marginalized our group, Black Patients Matter. But I'm very happy to see that the medical board has really progressed and that the problems are being smoothed out and that we're moving forward. But I can assure you that Kirchmeier is continuing in her practices at Black Patients Matter. Will address it with her. Thank you.
Thank you for your public comment. At this time, I don't see any other requests in queue.
Thank you. We'll bring it back to the board. Do any board members have comments or questions?
Ms. Lawson, this is Dr. Thorpe. I just had a question for Mr. Perez about the physician wellness program. I know that it was just referred to you earlier this month, but I wondered if you could give us some kind of a timeline on when the DCA could be completed with review of that program.
Thank you, Dr. Thorpe. I do not have an update related to the physician wellness program, but I will collect relevant information and provide that to Mr. Prasifka for distribution to the board. Also, if I may, I would also like to congratulate Mr. Brooks, Ms. Lubiano, Ms. Campoverde, and Dr. Hawkins on making progress in the Senate confirmation process. So, congrats.
Thank you. Additional comments or questions? All right, we'll move on to agenda item 16, an update on the Federation of State Medical Boards, which is my item, and I will be extraordinarily brief. I did attend on, as the California Medical Board's voting delegate, the House of Delegates meeting of the Federation of State Medical Boards, where the board conducted its regular business, and perhaps most importantly, For this board, Denise Pines, who is our former board president, as she is now a member of the Osteopathic Medical Board here in California. But Denise has been elected to the board of directors of the Federation of State Medical Boards. So California's interests will be well represented at that level. I know Dr. Kraus attended part of the FSMB's annual meeting as well, and I think he'd like to just provide a minute or so update about that.
Thank you, Ms. Lawson. I've attended meetings of the FSMB for several years now, and I would commend to all of our board members who may not have participated that this is an opportunity that you should take advantage of. If you go to fsmb.org, there's a simple process to sign up, and every state medical board member is invited to be a member of the FSMB. One of the privileges of being in the United States is that there are 50 plus different experiments going on in the different states of the United States. And on our board, we seem to approach every problem as a unique new problem. But there's much that can be learned and we can benefit from, and we can provide benefit to other state leaders through the platform of the FSMB by sharing concepts and sharing experiences. I've had the privilege of serving on a couple of committees for the FSMB, their committee on marijuana, their committee on stem cell therapy and regenerative therapies. And I've been able to bring back cumulative thinking and FSMB committee decisions to our own medical board to help us make progress in those areas. So if our board members will participate in the FSMB, it'll be of great benefit to the medical board and to the people of California. This year, the meeting had some highlights and discussions in relation to the pandemic, of course, also in relation to emergency preparedness, healthcare equity, AI, telehealth, and most importantly, regarding physician impairment and health and wellness programs. But even if one did not attend the virtual meeting is still available and recorded by online access. And I would just like to reiterate that this is a very valuable resource available to all of our board members, and please be an active participant. Thank you, Ms. Lawson.
Thank you, Dr. Kraus. Are there any questions or comments from board members on the FSMB? Right, hearing none, we'll open this up for the public.
Okay, I've gone ahead and activated the Q&A box and the hand raising feature. If anyone would like to make a public comment, please indicate so there. First up, we have Hannah Ree. Hannah, go ahead.
Yes, thank you. So this is Hannah Ree of Black Patients Matter. It's quite interesting, myself having attended the medical board meeting in California and then also the one in Hawaii at the same time, how there are such similarities. And the one thing I keep hearing about is the FSMB. And so the FSMB, what we have found here at Black Patients Matter is currently striving towards improvement, but is part of the problem. So in terms of structural racism and healthcare disparities, FSMB is currently part of the problem, but could be part of the solution. So there are individuals, many individuals, sadly to say, Mr. Kraus is one of them, but excuse me, Dr. Kraus, but there are several others who are participating and are also members and representatives of their medical boards who have absolutely no work experience in racial diversity and religious tolerance and LGBTQ rights. However, they seem to have found themselves a way to become voting members of the FSMB. So we at Black Patients Matter, California, we will push forward with our agenda in improving the health equity condition in the United States. Thank you.
Thank you for your public comment. This time, I don't see any other requests in queue.
Thank you. We'll bring it back to the board. Are there any additional comments or questions? Right, seeing none, we'll move on to agenda item 17, an update on the Mexico pilot program. Mr. Prasifka.
Thank you, Madam President. I can be brief on this matter. Just to briefly update the board, the Mexico pilot project became effective under AB 1045 in 2002. It was enacted in January 1st, 2003. As I updated the board at the last board meeting in February, that at the end of January 26th, there was finally completed the interagency evaluation agreement involving UC Davis to conduct the evaluations. Once that was done, the board was then satisfied that it was in a position that it could issue licenses. As I indicated at the February meeting, the board was prepared to issue 20 licenses of the 25 applicants that had absolutely no deficiencies. The applicants with no deficiencies at that time had requested the board delay issuing their licenses until they are further along the visa application process to ensure that they can practice for the full 3 years. At the moment, we have not received any request to issue the licenses. We had hoped that we would be issuing the licenses in May, although at this point it looks like it may not happen until June, but we have been informed that the licensees are hoping that they can begin practice in August. So again, we are ready to issue 21 licenses. We're just waiting to get the go-ahead, and I'd be happy to take any questions.
Mr. Prasifka, thank you. Are there any questions about the Mexico pilot program from the board members? All right, seeing none, we'll open this back up for public comment.
I've gone ahead and activated the Q&A window and the raise hand feature. Anyone would like to make a public comment, please indicate so in there. First up, we have Hannah Ree. Hannah, go ahead.
Yes, hello. This is Hannah Ree again, Black Patients Matter. So it's truly wonderful to see the medical board moving forward with the Mexico pilot program. I keep hearing about it now for several years, and so it's nice to hear that 20 of the 25 are licensed. I guess my concern is this: is that certainly we do welcome our brothers and sisters across the border, and you know, encourage them and want to share knowledge with them and that sort of thing. I guess my concern is that when physicians from Mexico work in areas, the United States or in California, I'm concerned that they are not aware of the healthcare disparity amongst African American patients. And so I certainly hope, of course, we all understand that being Hispanic is an ethnicity, not a race. So I certainly hope that they are welcome to treating anyone who comes into their clinic or into their care, and not you know, becoming a type of practice which treats white patients only. So I applaud the medical board for giving these licenses, but I certainly hope that it would not result in marginalizing African American patients. Thank you.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thank you. We will bring this back to the board. Are there any additional comments or questions? All right, seeing none, this looks like a good time for us to break until noon, and then we'll come back for some strategic plan and some items where I think we'll be digging in a little bit more. So let's take a break, 10-minute break until noon. Thank you, everyone. All right, I have 12 noon, so if members, if they're making their way back to their screens, could turn on their video once they return. Thank you.
Christina, where are you today?
I am in Walnut Creek right now.
On Walnut Creek.
Yes.
But you live in Southern California, correct?
No. I live in Walnut Creek.
I think I knew that. My son has his U of A orientation next week.
Oh, he is going to U of A. I was going to ask you about that. We can do
Yeah.
it now, but that's
Yeah.
terrific. We'll talk more about that.
Yeah, he's
later.
very excited. I'm very proud of him.
That's terrific. All right, Sean, are you ready to, or are we collectively ready to go from your perspective?
Yeah, you're ready to start whenever you're ready.
All right, so our next agenda item is agenda item 18, which is an update on the 2020 activities of the 2018 to 2021 strategic plan. And this is Mr. Varghese.
Thank you, Madam President. I'll be really brief. You had this opportunity to review this report that's in your notebook. And we'll start off with the licensing, what achievements we were able to chart during calendar year 2020. So often during almost every board meeting, the board members had the opportunity to listen to the 6A report where we talk about the docs portal, especially the portal helped during the pandemic in streamlining obtaining the documents that are required and necessary for the licensure process. So that is a major achievement. And also during in January 2020, the board implemented some law changes that required California residents to obtain postgraduate training license. So 2020 was a major, as you know, a transitional year. The board had to adjust to new process and procedures. And in addition, the board issued about 23 more licenses in 2020. And it was a major achievement considering all the hurdles and the speed bumps that was placed in front of us with all the pandemic and the employees teleworking. So again, going to that part of it, it was a transition process to go from on-site staff working to teleworking. A lot of adjustment had to be made, and some smooth kudos goes to all the managers and licensing chief and ISB and the executive staff who worked hand in hand to make sure there is no stoppage in our service in licensing activities. And during COVID-19 pandemic, Department of Consumer Affairs helped implementing a lot of waivers to extend deadlines. Without those waivers, it would have been tough to continue licensing and also the physician and surgeons to, and also postgraduate training licenses to provide the service to the public. And so these waivers helped them to stay focused on taking care of the patients rather than worrying about their license going to expire and things like that. And also in 2020, but we saw about 12.5% increase in online license renewal. And also during 2020, because of pandemic, we were able to rely more on electronic communication and email notices for renewals. So that's some major achievements in licensing. On enforcement side, January 2020, the new law requiring mandatory reporting went into effect, and also during this calendar year 2020, we were able to decrease the average number of days to initiate complaints, and we continue to make progress in that regard, as you know, when we report to you on agenda item 6 every time the board meets. And the number of pending complaints also saw a downward trend by 50%, and the number of cases over 1 year decreased to over 80%. Are some major milestones achieved, and we continue to make progress there. And DCA and Department of Public Health, also California Department CDPH, provided 2019 death certificate data during November of 2020, and during this calendar year, we changed the program name to Prescription Review Program. formerly known as the board's death certificate project. And during 2020, we looked at and continue to look at going more paperless, and it started to show some improvement in this in the task improvement and speeding up the process, and also cost savings across the border in enforcement division. The medical board's consultant program staff worked with reviewers assigned to cases older than 30 days to ensure timely resolution, and we continue to look through that process improvement. And also expert program conducted training via WebEx, and that was a major shift, primarily due to COVID, pandemic and lockdown and shutdown, but we are very fortunate to have that WebEx platform that we were able to continue to provide much needed training for new experts coming on board or any other experts that need refresher training. Going over to legislation and regulation, the featured newsletter article in spring 2020 on board's pending legislations page on the website, and outlining the legislative bills that the board is monitoring and how consumers can be engaged in the legislative process, was published. Review of the board's existing laws and regulations, and also stakeholder suggestions to identify needs changes. And also several rulemaking files are in progress that's initiated in 2020. Then quickly going over to the outreach effort. We have more to report in 2021, but in 2020, on-site events were suspended due to the COVID. That means we were not able to travel to traditionally travel location to meet with the stakeholders. However, we were able to continue with teleconferences with stakeholders and actually have more interaction and more time we're able to devote to those interactions because of the online interactions and the frequent interactions, and also save some travel cost in that regard. And also the board's outreach consists largely on social media messaging. We increased the number of Twitter feeds and emails and newsletter articles during 2020, and also developed full media campaign to include videos and podcasts and social media messaging, and also helped with recruitment of expert reviewers using those platforms. And in early 2020, the board collaborated with the pharmacy board to issue joint statement to licensees regarding the hoarding of medicine. And finally, in administration, the board's president and vice president attended the February 10 all-staff meeting. The annual President's Employee Award was presented at the January 2020 board meeting, and also success achieved in continuous process improvement and efficiency savings. We were able to report a few of those to you last time, and we'll continue to catalog all those improvements and efficiencies. And I'm here to tell you it's not something that we stop with 2020. It's continuing, and it's gaining speed and momentum, not just in one division, but across the every division, every unit in this agency. And we have very motivated staff that are looking at their surroundings and their processes and continuously bringing up new ideas to improve their day-to-day task. And also, we were able to establish a staff well-being group during 2020. So those are my prepared statement, Madam President. I can answer any questions.
Thank you very much. Are there any questions or comments from the board members? All right, seeing none, Sean, let's please open this up to the public.
Okay, I've activated the Q&A window and the hand raising feature. If anyone would like to make a public comment, please indicate so. Give another few seconds here. First up, we have Hannah Ree. Hannah, go ahead.
Yes, thank you. Hello, this is Hannah Ree of Black Patients Matter. I wasn't sure if maybe this was the correct time to just emphasize one point, but if, again, when the medical board hires or contracts the medical specialists, medical consultants, it'd be very relevant to utilize those that show on their CV or their resume that they have worked in areas of racial diversity and religious tolerance. because, certainly if a physician chooses to, work in an area, or he just, works at a population where the patient profile is very not diverse, let's say, not diverse. I mean, so certainly they have a right to work in that fashion. That's where they live, they work, but that should not be a that should not qualify them to work as a medical expert or consultant for the state of California. I would envision and hope that those who are medical experts and consultants for the state of California show on their resume that they have worked in a racially, financially diversified patient population, that they have worked in a religiously diversified patient population. Why? Because those traits and characteristics are important in terms of patient care, especially when it comes to psychiatrists. So just wanted to emphasize that point again. Thank you.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thank you, Sean. We'll bring it back to the board. Are there any questions or comments before we move on to the next item?
Yes, I've got a quick question.
Mr. Watkins.
Reggie, the new strategic plan that we're mapping, I see you've got a process map out. When will that begin? Do you have a time frame of when it will start, and when will we have a complete new strategic plan?
So Mr. Watkins, let's move on to the next item, which is the update on that process. And then I think Reggie has a presentation for us. Is that acceptable to the remainder of the board?
So are we done with agenda item 19?
Yeah, I'd like to just conclude that so we can move on to this next, which I believe, Mr. Watkins, is what your question is about, this roadmap. Yeah, okay, thank you.
Thank you, Madam President. So this is Mr. Watkins, right? Nice segue into the next item here, 2022-2025 strategic plan. And to present this item, I'm going to invite Ms. Elizabeth Cornell. She's a strategic business analyst with DCA. She will be the key person to guide us, us meaning the board and the staff, and all involved parties through this process, and she would be going over this presentation for us today. Ms. Cornell, are you?
Good afternoon. Thank you for having me here today. I'm Elizabeth Cornell, Strategic Planner and Facilitator at the DCA's SOLID unit. SOLID will be assisting the Medical Board of California in its strategic planning process. Today, I'm going to go over the board strategic planning roadmap and answer any questions you may have regarding the process. So the strategic planning process at DCA consists of 5 main parts. You have the setup, the environmental scan, planning session, the creation of the plan, and action planning. The first part has been completed, which includes a customized process for the board and the deliverable schedule. The next part is the environmental scan. This will consist of surveying stakeholders, board members, staff, management, and the executive team to gather feedback on the board's internal strengths and weaknesses, or areas that can be improved, and external factors impacting the boards, these being the opportunities and threats. The feedback will be then compiled into a report, and summaries will be created to emphasize those trends found in the comments or the feedback. The final report, the environmental scan, will then be reviewed with the board in preparation for the strategic planning session. This document will assist board members and the executive team in developing its next strategic plan. During the planning session, the board members and the executive team will develop strategic objectives for the board's upcoming strategic plan. The environmental scan's weakness, opportunities, and threats sections provide ideas for possible objectives. After the actual planning session, SOLID will draft together the plan of the objectives that you all develop and send it to the board's executive team for review. The strategic plan will then be finalized and edited if needed and approved by board members This typically happens in the following board meeting, following the planning session. And the last part, the action planning, Solid will facilitate a session to assist the board's executive team break down each strategic objective into specific tasks, due dates, and assign it to classifications or working titles and determine performance metrics. So that is the roadmap that we're going to take for the board's strategic planning process. Do you have any questions?
Do board members have any questions or comments?
Yes, I have a question. Did we go through the same process back in 2018 in this startup process? Has anybody?
I apologize. Thank you, Mr. Watson. That's a good question. Yes, so we are following the same roadmap as we did in 2018.
Dr. Hawkins.
Please.
Any dates, start dates, perhaps?
I have tentative dates. I would like the board executive team to confirm that, but I do have a starting month of August and the planning session perhaps November, but I would like, those are tentative dates. I would like the board executive team to confirm.
Though those are the dates what we talked about. We already met with Ms. Cornell and Letitia. Bill and I met during the preliminary meeting, and we can identify those dates. So our goal is to finalize, get to the 5 weeks process by about by the November board meeting. That's our goal at this time.
Any additional questions from board members? All right, Sean, let's please open this up for public comment.
Okay, give me the second half of the presentation to open the Q&A window there, and anyone wishing to make a public comment, either enter something into the Q&A window or raise your hand. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, hello, thank you. So this is Hannah Ree of Black Patients Matter. A couple points. Number one is that I'm wondering if we should be following the same roadmap that we did in 2018, because I'm wondering how successful that roadmap was, or that you know, those meeting times. The other thing is that I noticed that for public stakeholders, we're only included during one phase briefly in this process. So it would seem logical to perhaps include us more often in this process, especially for having a quarterly stakeholder meeting. And seeing as how there has been really a seismic shift with Mr. Prasifka on board, Mr. Watkins and others, and Ms. Alejandra, I'm wondering if perhaps we should include more of public stakeholders in this process. Thank you.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thank you. We'll bring it back to the board. Are there any additional questions or comments before we move on?
A quick question. Will we be able to establish from our first, maybe staff can prepare that before we get started. I didn't see any matrices, so measurable outcomes that we set out in the previous strategic plan. I just want to see if, because we're getting a list of all the things achieved. And I would just like to, before we start the next one, get a real clear line by line. How did we do on this one item? How did we do on that item? Even though new things have surfaced. Because it is a strategic document. That's what I mean.
Ms. Cornell, do you have a response to that?
Thank you. That question, and just to rephrase the question, you would like a update on the previous strategic plan, correct? And to see if those objectives were accomplished?
That's correct.
I would leave that for a board executive team. Once Solid develops or assists the boards in developing their strategic plan, they pass it over to the individual boards, and we do assist with action planning. And beyond that, the boards can track if they have completed those objectives, and if the board members request, and if the executive teams can fulfill that request, give an update whether those objectives were completed.
And I guess I would add, I mean, we have been tracking our progress on the 2018 to 2021 strategic plan. So perhaps, Mr. Watkins, it's just a matter of having our board staff format that in a way that's useful to this process, because it has been tracked over the course of the time period, including the presentation Reggie just gave before, but it's not tracking, you know, for example, if we didn't meet one of the objectives or that sort of thing. So perhaps we can do that and have that update come at the next board meeting, excuse me, at the board meeting at which we start the process as a board for the next strategic plan, so we're informed by that information.
Absolutely. I would take this opportunity to just highlight that maybe a couple of board meetings ago, we looked at to see if we reach some of the measurable goals that were set in this current strategic plan. And that's when we identified that to reach some of those goals, we had to go through a statute change. And we were able to incorporate that into our sunset process to change our BPC codes to allow us to do more online renewals and online applications, which was a goal that was set in the current process, but we were able to move that direction because of that analysis. So absolutely, when the plan sets out some measurable goals, it's easy to track them, and so we would do like what Ms. Lawson said. But by the time we close out this current plan, we'll be preparing a report to report on our achievements based on what goals were set back in 2018.
Great. Any other questions or comments before we move on? All right, let's move on to agenda item 20. Mr. Varghese, you're up again with a update on our budgetary position.
Thank you. I wanted to go over and highlight line by line item, and please stop me if I'm taking more time, but this is a very important report that and especially for our new board members coming in, we are going to look at this report that's in your packet, agenda item 20. It's a one-page report, and basically just pay attention to the previous financial years, 2017-18, 2018-19, 2019-20 actual expenditure, and then we will be comparing those to the current year revised budget, and then also look at what we have spent through financial month 8, that will be end of February, and then there's a projected spending for the rest of the financial year and where we will end up. So that's what the analysis is going to be today, and I can take you by line item to explain to, and then if you have any specific questions about any of those line items, I'll be happy to answer that the best I can. So the first line item is the salaries and wages for permanent employees, and we have budgeted $11.35 million budget for this financial year, and the actual spending equals about 58% of the budget so far. And the total spending projection through end of the financial year is estimated to be about $9.89 million, with a savings of about $1.46 million. Now you have to understand what aspects and what items contributing to either the reduction or increase of this line item. You have to, you probably already know that the board, much like all other state employees, have to agree to a 9.23% salary reduction or salary cut in exchange for a 2 days of what they call personal leave program of 2020. And that contributed to some savings here. And also a year ago in 2020, the vacancy rate ranged from 13 to 14%, but now we are at about 8.7%. So when we reduce vacancy rate, the salary goes up. So I just wanted to show you two contributing factors that can affect either reducing that line item or increasing it. And the second line item is temporary help, and this is based on an as needed. This is how it's estimated and budgeted. 756,000 was budgeted, and we spent about 31% of that through end of February. And statutory executive salary budgeted based on the actual amount. It was under budgeted by about $26,000. And going forward, this line item should accurately reflect actual amount and not result in any kind of variance. So in the next coming up financial year, we probably need to do a better job in itemizing that. So the board and commission line item is board member per diem based on estimate. Projection to the year end is based on average of 3 previous years' actual expenditure. Current year expenditure is already over current year budget for this line item. This line item should have reflected a higher estimate based on previous year's average, according to my calculation, and going forward, we'll have to allocate it appropriately. Overtime, one-time lump sum pay based on estimate again. Overtime work is generally discouraged, especially during financial crisis. However, due to COVID-related downtime, to cut down on increased backlog of PTL and physician and surgeon applications, some overtime had to be approved during this financial year. And because of that, we were able to achieve efficiency also. And so this line item also reflects leave balance payout in lump sum to retirees. So all that amount that's listed there is not all overtime. Out of that amount, about $101,000 equals payout, lump sum payout to the retirees that retired from this board. Staff benefits based on trend and is formula driven with calculations based on staff salary. Fingerprint reports, that line item is based on estimate. Through end of financial month 8, we spent about 66% of this line item. However, expecting to close the year out to match previous year's actuals or to exceed slightly because of increase in number of applications or licensure. Applicants do reimburse the board for the administrative cost of fingerprinting, so we do collect some of that money back. General expenses based on prior year estimate, underestimated this line item budget, and we hope to close out the year spending close to about $150,000. However, for future financial years, this line item should see a reduced spending pattern, and that is because of cost reduction and process improvement initiatives undertaken by the board this financial year. So only few years down the road we'll be able to see what this compares to the previous or this current year in the future. Printing based on estimate again and also past expenditure. This line item in calendar year expenditure figure of $337,000 do include an encumbered amount of about $200,000. So that's not all the money that we spend. There's still some in purchase orders, about $200,000. So we anticipate seeing savings in the amount of about $100,000 on this line item because of improvements carried out in this financial year by not renewing certain printing contracts, not printing the winter newsletter, etc. Postage, that's also based on 3 previous years' average expenditure. We budget to spend about $154,000. However, because of process improvements carried out this financial year, we anticipate ending the year out by only spending about 50% or less of what was budgeted. Insurance is also, it's estimated. It was way underestimated according to our calculation. This line item based on financial year 1920 actual expenditure. Major share of the funds spent to are for vehicle insurance, pay for vehicle insurance. We will have to drill deep down on this line item going forward to better project future expenditure. Travel in state, again based on previous trend, Due to pandemic-related travel restrictions, we hope to save about 95% of this line item budget. Training, based on number of training events planned and prior year trends. So this is in addition to staff training expense. This line item is for costs related to reimbursing training fees and trainers' travel expenses to train new experts. We might close out the financial year spending by about 75% or less because of savings realized by moving those trainings to WebEx platform. Facilities operations, estimated based on past spending pattern. This line item was under budgeted this financial year. This line item primarily includes rent payment and other facilities related expenses. We spent $20,000 this financial year for COVID cleaning alone for the central office here at Evergreen Street. So that money is part of the facilities operation. Consultant and professional service internal. This is contingent upon situations at hand and what cases are being defended. This includes medical and external legal consultation. We budgeted $313,000, and the current year expenditure through end of February do include an encumbered amount of about $113,000. In my estimation, we may only end up spending about 42% of the budgeted amount. Consultant and professional services external should be budgeted based on average of previous 2 years. So this line item includes assortment of services. However, over 95% of the budget is to pay for credit card fees. So this is way under budgeted according to the report here. And going forward, should do a better job in appropriately fund this line item. Interagency services should be based on previous year's trend also for Department of General Services charges. This is also under budgeted, and going forward, we need to do a better job and appropriately fund this line item and reflect the actual amount. DCA pro rata, it equals the budgeted amount, so there's no variance there. Consolidated data center, estimated based on need that are at hand and a prior trend, and we expected to spend only about 50% or less. Information technology, same thing. We expected to finish out the year with about 100% of the budgeted amount there. Department of Investigation, HQIU, estimated based on workload at hand. So this projected to end this financial year with some savings based on end of fiscal February 2021 estimates. Vehicle operations, due to pandemic-related shutdown, spending on this line item so far only amount to about 13% of the budgeted amount. Attorney General's estimate based on caseload and type of cases handled. And yesterday in the presentation, Ms. Castro mentioned that she would be happy to have their budget person to come and talk to the board in the future. So we will be looking into that for them to come and better explain to us. But based on the billing through February and estimate for remaining 4 months of workload, it is estimated that this line item could result in a deficit budget of about $1 million for this financial year. Office of Administrative Hearing is also estimated based on caseload and type of cases. Based on billing through February and estimate for remaining 4 months of workload, it is estimated that this line item also could result in a deficit budget of about $700,000 for this financial year. Evidence and witness fees is a straight line estimate based on past financial year trend. Due to pandemic-related cut down, online hearings conducted, etc., only 56% of the budgeted amount is spent through end of February. Court reporter is also a straight line estimate based on past trend. A separate line item budget was not introduced for this line item for some reason this financial year. Expenses tend to follow the similar course when you look at the previous year's expenditure. Finally, equipment, also straight line estimate based on past and financial year's trend going forward. And expenses is expected to reach at or about the amount budgeted. So in a nutshell, in reviewing the individual line items, few are projected to end with deficit while the others show some surplus and savings. So according to this report at the end of February, we are expecting a net total budget is expected to end with a 1.33% surplus. Now, that is like a drop in a bucket when you compare to the total picture. It is not enough to, it is not a sustainable savings that we would like to see our fund balances to go up in a dramatic fashion. So we still do need, this is a reflection of all the good things we are doing, all the streamlining and cost cutting and cutting out the waste and all the efforts of our staff. That we are staying well within the budget, even though some budget factors are going up beyond our control. But what is in our control, we are doing a good job at it. So with that, I'll conclude my prepared remark, Ms. Lawson, and I'll be happy to answer any questions.
Thank you. Any questions or comments from board members?
I do. Quick question for you. Under facilities operations, that's basically the rent and maintenance that we pay. But what square footage do we utilize right now? Do we know?
I'm sorry, Mr. Brooks, what?
Do we know what square footage we rent?
Square footage, we have not just one location here. We have we have this location, and then we also rent space with HQIU in our field offices in different places across the state. And I do have that information, but not readily available with me at this moment. But I can definitely share that with you.
And the reason I'm asking the question is, you know, we pay a lot in rent. Have we looked at just purchasing a building outright? You know, if you're going to spend, you know, $1 million and $1.2 million a year, you know, depending on what square footage you are, probably paying, you know, something around, you know, $250 a square foot, which is, you know, pretty low. But you could probably, you know, purchase a building, advertise that over 30 years and have an asset.
That's something we have to work with the DCA and the state facilities group. But let me see some smile around the room here when we start talking about it, because that's exactly what we are looking into right now. We just recently, we have a spreadsheet that shows the square footage of all the buildings that we pay rent for and where they are, and also we are locked into the multi-year lease in many of these sites, so we really cannot, you know, get out of that, as you would know, that, you know, without some penalties. But we are the sites that are coming up for renewal. We already started with the one site in San Jose that DCA is working with us to move into a different location, and also we are looking at cutting down on the total square footage wherever we can, because, you know, the COVID had contributed or opened up channels for teleworking, and so we don't have to use all the square footage that we are paying rent for right now. And so we can also look into space hoteling type feature, where we can allow staff to come in and work telework and also share the space, basically. So, but again, those are initiatives already charted in our process improvement. Those are categorized as category 3, which means that's something we'll be continuously look at, and we'll be bringing up for discussion and action when the lease is coming to close. The current lease is coming to close. So we'll negotiate going forward.
I appreciate it. You're already on it, so I appreciate the good work, and thanks for the fantastic presentation.
Additional comments and questions?
Yeah, Mr. Varghese, Dr. GnanaDev, Ms. Lawson. So the two biggest expense beyond the budget or increase in the budget, it looks like, is the external consultants and AG's office. Can you explain to us why? And also biggest drop, it looks like, is HQIU. So I'm just a little confused on that one.
Right. So the Attorney General's office, like I mentioned in my remarks, that it all based on, I mean, I wish I can say this, so I have to take my financial hat off and put just look at the cases that we look at, the board members and the staff. It's not really black and white when we look at it. So we cannot, it's not like the rent that's same every month. It's all depending upon how many cases they're handling and what type of cases they're handling. And also remember, we are tasking HQIU and Attorney General and everybody else to speed up and get caught up on all these aging cases. So that when the workload goes up, the cost goes up. So it's more like you want the steam engine to go faster, you had to put more coal in it. So it's that analogy basically. So you just have to spend more. So the spending is increased, which actually correlates with added task to these contractors that they have to deliver more, and that's the way I look at it. That's why I see the cost going up.
Well, that doesn't explain the cost going up on the external consultants and the AG's office, and at the same time cost going down on HQIU. That's why I wanted to hear from you why that discrepancy.
Yeah, HQIU cost was projected through the Department of Investigations, and that's their estimate that was given to us, and we can drill down deep into it. I only have some surface numbers here today with me, and that could be an item we can analyze and bring it back to you.
Okay.
Mr. Rue, I saw your hand up, or sorry, Dr. GnanaDev, are you finished?
Yeah, I'm just still, I'm still not satisfied, Reggie. I understand what you said, but are we taking the workload away from HQIU and giving it to the AG's office? I'm just trying to figure out why savings in one, cost going up on the other, and I'm just putting my MBA hat on now, not my MD hat on. I'm just trying to see why. And then suddenly there is a large increase in the external consultants. So that's why it was a little confusing to me without decent explanation. And I haven't heard yet, at least for my satisfaction.
Yeah, the external consultation, majority of that is basically the credit card fees, and believe it or not, sometimes those category as they labeled are confusing. We think about those are consultant for enforcement, but basically that line item, external consultation, is a 2-year average of about 983,000 for L1 and 261,000 for American Express. So those are credit card fees that we have to pay for credit card payments that we collect, and those do go up and down based on the number of transactions. I don't have the details for that. This is like the summary that I have right now. Now, HQIU, the reason why I didn't want to speculate why that is going down, one of the reasons could be that we are referring less. They're speeding up on the process and based on the caseload numbers. But I need to look deep into it to give you the right answer, so I don't speculate on the wrong side of it.
Okay. Okay. Thanks.
Sure.
All right, Mr. Rue, I saw your hand up.
Thank you. Mr. Varghese, did I say that right?
Varghese. You're fine.
Varghese. You know, if I'm reading, actually, you kind of answered my question, but to go back to the doctor's question, if I'm reading this chart correctly, both for HQIU and for Attorney General, from the actual budgeted budget to the revised, they both went up. So it looks like Attorney General got a 40% increase and HQIU got something like a 55% increase. So the end numbers of the Attorney General, at your projection of costs going up and HQIU costs going down is actually misleading, because actually they both got increase in the budget. So the reality is they're both over budgeted. It's just that it looks like the budget got covered. Am I reading it wrong?
Well, so when you're looking at the HQIU budget going up, you're looking at the 21,904,000.
Well, it looks like your current year expenditure was 13. Oh, so it's 13 what's currently spent?
Yes.
Yes. Okay, all right. So I'm reading it wrong. Okay, so that question is a valid question, and I'm curious about that as well, especially when HQIU has the highest caseload. But going back to my original question, you kind of answered. You said the external consultant costs, credit card fees. Can you explain a little bit more? What do you mean by credit card fees?
When someone make a payment on with the credit card for fees for applications on renewal, there's a service charge based on the type of credit card. So that is being charged to the board, and then we have to make the payment.
Okay, so it's basically service charges on license fee renewals and etc. It's not that it's credit cards that we're using.
No,
and,
sir.
And holding a balance. Okay.
No,
Great.
we don't. No, we not. Absolutely not.
Yeah, these credit card fees kill you. Yeah. Thank you.
Additional questions before I call for public comment? All right, Sean, let's open it up for public comment.
Okay, the Q&A window is open. Anyone wishing to do so, please type something in there or raise your hand and we'll call on you in order received. First up, we have Hannah Reed.
Yes,
Hannah?
hello, medical board. Yes, Hannah Reed, Black Patients Matter here. So a few points, a bit of the feedback here. So of course, we're all focused on the budget. So with the HQIU fees going down and then the AG's office going up, it's not inexplicable to me. It's not suspicious to me. It's very obvious. So for myself, as you know, the petitioner for multiple federal lawsuits, I can tell you that they are, rather than every time before I file a lawsuit, I always ask, do you want to mediate this? Do you want to discuss this? No, let's go to trial. So the AG money, the AG's office is making a whole lot of money off of you all, okay? Remember, Mr. Prasifka had stated that the HQIU had a large sum of money that was unaccounted for. So this is what we're seeing now in the AG office. And what are you paying more for? Where are the results? There has never been a retrospective study to see if the AG is doing their job, that if in fact they are decreasing recidivism rates amongst physicians. There's no studies to show that you are getting your money's worth. All you're doing is putting up with some, wonderful woman coming in to speak with you very nicely about how they need more money, and you give them more money. What do you have to show for it? Nothing. Okay. So the second thing is that the expert and consultants. So again, you're paying a lot of money for experts and consultants that could very easily be paid less for. You don't need to pay as much money for them because it's not necessary. Obviously, because look, at the end of the day, there has never been a case at the OAH's office. No judge has ever dismissed a case. If anything, they have given a large when it goes to the board. So the AG's office, $1 million plus a deficit. Look, you're paying too much. They're obviously scamming you. And after we file our next federal lawsuit, you will see how they are misusing their funds in order to target underrepresented minority physicians to ruin their
30 seconds
thank you. Well, sometimes to ruin, but also to affect their practice, affect their income. It's a formula that's utilized by corrupt police officials around the country. It's not unheard of. So it's time for a budget cut. We have police forces around the country. New York City is one of them that used to have $1 billion budget, but it's since been cut. I mean, there's been some controversy about it, but that's what you're doing right now is you're funding
Please complete.
Yeah, so in any event, thank you for listening.
Thank you for your public comment. Next up, we have W. Brannon. W, are you there?
Yes, I am. Thank you. I noticed that you have a severe reduction or expenditure to your training. I find this a little bit disturbing because even though with the pandemic, I believe, especially with the severe turnover of staff member over the last 4.5 years, that training is essential for all of your employees and your investigators to do their job. And the medical board should be looking at an online format of training. and have that done in a more effective manner. And it would also allow for a reduction of costs, and it could be completed and monitored a little bit differently rather than in person. I also noticed in your technology department, and I'm speaking in regards to the last 4.5 years, there are investigators for the medical board that go out in the field and don't have charging cords for their phone in order to take notes. They don't have tape recorders or the necessary devices to gather the information in hearings. And I believe that, and I don't have knowledge of how you do it or what you provide your investigators, your staff, but I believe that there are essential tools that all employees should have when conducting their job in order to gather accurate information. Your Attorney General's office is essential. Your expert witnesses are essential. And if your investigators don't have the tools to gather the information that they can accurately, the Attorney General and expert witnesses cannot be utilized to the best of their ability because they may not have accurate information. So I think one, online training needs to be looked at, providing essential tools and services for your investigators are necessary. And with the training, you have a high turnover of staff, and there needs to be better training overall for everyone. Thank you.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thank you. We'll bring it back to the board. Are there any additional questions before we move on to the next item? All right, seeing none, we will move on to agenda item 21, update on the Health Professions Education Foundation. This is Dr. Hawkins and Dr. GnanaDev, who are representatives to HPEF.
Thank you very much, Dr. Hawkins will be giving that update. I hope you can hear me. The Health Professions Education Foundation Board last met this Wednesday, the 12th. The board also had a special meeting with the Office of Statewide Health Planning and Development, OSHPD, leadership on May 6, 2021, and I'll indicate what that is. That's for the bulk of my presentation. The Health Professional Education Foundation, HPEF, improves access to health care in underserved areas of California by providing scholarships and loan repayment programs to health professional students and graduates who are dedicated to providing direct patient care in those areas. In return for this support, recipients agreed to provide direct patient care in a medically underserved area of California for a period of 1 to 3 years. OSHPD has been elevated to a department. It's the Department of Healthcare Access and Information. OSHPD has proposed bill legislation that will affect HPEF. I refer you to the OSHPD recast and modernization fact sheet at oshpd.ca.gov, oshpd.ca.gov. I'll provide relevant highlights of this fact sheet. The issues. The statutory changes recast the Office of Statewide Health, OSHPD, as the Department of Health Care Access and Information. It strengthens healthcare workforce and other data assets, build a more robust health workforce data system, and analyze that data to a better informed policy recommendation to help support the state's healthcare workforce. The justification for the change. The statutory change helps support the state's role in developing and sustaining California's healthcare workforce. Also, the substantial expansion of OSHPD's mission with the addition of an Office of Healthcare Affordability. OSHPD recasts into a new department, improves the department's capabilities. Relative to HPEF, OSHPD seeks efficiencies by operating the Health Profession Education Foundation workforce programs as part of the new department's existing workforce portfolio while maintaining its licensed revenue streams. HPEF was established in 1987 to provide a clear way for private tax-deductible donations to support scholarship and loan repayment awards for aspiring healthcare professionals. However, it's unnecessary for the state program to remain under a 501c3 to provide tax-exempt treatment of donations. due to its 501c3 status. Accounting and audit requirements of HPEF are costly and burdensome. The existing funding streams will continue to support these important scholarships and loan repayment programs. If approved, this will result in the dissolution of the HPEF board by the end of this year. That's the end of that report.
Thank you, Dr. Hawkins. Are there any questions or comments?
Yeah, Ms. Lawson, I think the important thing is there will not be Health Professional Education Foundation Board. I personally represent, it's not, I'm just giving my personal opinion, that may not be a bad idea because it's so difficult to stick a 501c3 into a government entity. So when I first went on, I was somewhat lost. What's our fiduciary responsibility as a 501c3 versus working as a government entity like Medical Board of California does? So it was difficult. That's what they did. I only think there will be a committee apparently appointed by the governor who will look into the scholarship programs, part of the new department. I wasn't sure if it is a cabinet level department or not. Maybe it is. It's still in the legislature. So one somewhat concern I had was that if that happens, I think medical board should be involved. I'm sure I'll be long gone by then, but I want to make sure that the board is involved in appointing someone to that committee so that we are still involved, especially on the LRP program, Steve Thompson Loan Repayment Program, because constant funding for that program comes from us, from the licensee fee. The occasional additional funding comes from DMHC fines and some insurance company. When they merge, they put some money into it, but constant funding is always from us. So that's why I want to make sure that we actually get involved to make sure that there are two persons appointed by the medical board into that committee when the committee comes on and the board goes away.
Thanks, Dr. GnanaDev. Yeah, please.
No, I was going to say I agree with Dr. GnanaDev, and I would remind folks who may not know that HPEF came out of the Medical Board of California, the prior president. And one thing was very, very positive. I've been on the board for about 3 or 4 years, and we had a substantial improvement in momentum, involvement with new board members and board leadership. So I hope that won't be lost.
Thank you, Dr. Hawkins. And having served previously as the board's representative to HPEF, I guess I would say I'm not surprised. And Dr. GnanaDev, I share your sentiment that it's probably the right thing to do here. I mean, I recall the HPEF board and staff, having challenges explaining to potential donors the differences between, why it was, why they weren't giving money to the state government, for example. There was always a lack of clarity, especially on behalf of the folks who would be the donors, as to who they were actually giving to. So I think it makes a whole lot of sense. It sounds like with the path forward. Are there other comments or questions from the board? All right, I'll open this up, Sean, to the public.
Okay, the Q&A window is open for anyone wishing to make a public comment. You can also raise your hand. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, thank you. 2 things. So this is Hannah Ree from Black Patients Matter. Number one, it's very difficult to hear Dr. GnanaDev. I don't know if anyone else has the problem. I'm sure he has something very important to say, and I would like to hear it. But for whatever reason, I can't hear what he says. It's just kind of mumbling. It could be that maybe he's too far from his microphone. Secondly, so I would like to suggest to the medical board that on days or times when there are no other speakers, but no other public commenters except maybe a couple or maybe 3, that the rest of the time for public comment be utilized for commenters to be able to.
Ms. Reed, this is an update on the Health Professions Education Foundation. Do you have a comment on the Health Professions Education Foundation, please?
Yes, I do, and I have a comment for you as well. Number one, so I would like it just to make it a priority or to encourage those that are in teaching, those that are teaching the new physicians, that I would encourage them to maybe speak with their residents or their medical students about, you know, when they write and design their CV or their resume, to also include any type of work in underserved areas or in areas promoting racial diversity, religious tolerance, and LGBTQ rights. So that's going to be an important entry into the resume and CVs of our future doctors. For those of us that are physicians now, certainly when we were growing up or going through our training, it wasn't even mentioned. It was not anything significant. But moving forward for the new physicians and new doctors, that would be of importance. And then for the chair, I do want to express my concern to you that you are continually curtailing and cutting off speakers of physicians of
30 seconds.
color. Okay, so I want to warn you, please, don't continue to do that. You may be doing it subconsciously, but it's not appropriate. Thank you.
Ms. Reed, please keep your comments to the agenda item from this point forward. You've been given latitude to speak, but please keep your comments to the agenda item. Thank you.
This time I don't see any other requests in queue.
Thank you. I'll bring it back to the board. Do we have any other further comments or questions on HPEF?
Ms. Lawson, I just want to give some update on how the scholarships are given to who. I think it's important for our board members and the public to know that both HPEF and the PHC, which distributes loan repayment scholarship for the candidates, is a preference is for socioeconomically disadvantaged people who want to take care of socioeconomically disadvantaged people. So that is a priority in both those entities, because I was on PHC board for over 10 years and I left, I don't know, about 4 or 5 years ago. And now I'm on the HPEF board. So it's extremely important. I don't want them to get confused that these scholarships are given away to somebody who doesn't work with minorities and underrepresented people.
Thank you. Any other additional comments or questions? All right, seeing none, we'll move on to an update on the Physician Assistant Board.
Thank you. The Physician Assistant Board last met this Monday, the 10th. The PA Board is now an independent board from the Medical Board of California. Its mission is to protect and serve consumers through licensing, education, and objective enforcement of the physician assistant laws and regulation. The Medical Board maintains an ex officio non-voting seat on the board. Currently, that's me. The PA Board does value Medical Board representation and input. Agenda item 26, there will be PA Board leadership who will be making a comment. The next meeting of the PA Board is August 9th, 2021, and the PA Board invites public input. That's the end of my report.
Thank you, Dr. Hawkins. Are there any comments or questions on this item? All right, seeing none, we'll open it up for public comment, please.
The Q&A window is open for anyone wishing to make a public comment. You can also raise your hand. First up, we have Hannah Ree. Hannah, please go ahead.
Yes. Hello, this is Hannah Ree of Black Patients Matter, about to comment on the PA board.
Please go ahead with your public comment.
Yes, thank you. So at some point, it would be relevant and important for PAs to be able to gain their independence from the Medical Board of California, as there are a larger number of underrepresented minorities working as PAs than there are physicians in the state of California, and they do an excellent job of caring for patients. Thank you.
The PA board is now independent of the Medical Board of California.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thank you. We'll bring it back to the board. Are there any other questions or comments? All right, seeing none, we will move on to agenda item 23, update on revising guidelines for prescribing controlled substances for pain. Mr. Prasifka.
Thank you very much, Madam President. My comments will be brief. The task force has been established since the last board meeting, and we held our first meeting last week. Present were the task force members, Dr. Thorpe and Mr. Brooks, and we're grateful to them both for devoting their expertise to this very important area. And it was attended by the senior executive staff led by Letitia. We have the executive staff have our orders in terms of moving the project ahead. We need to secure one general contractor, subject matter expert to oversee the project. We're going to be developing a timeline. One of the first things that we need to do is to identify those parts of the guidelines that need to be updated because of legal changes. And then we have to identify those areas which we will engage with subject matter experts to identify all of those standards of care which will need to be changed, reflecting best practice. We are absolutely dedicated to engaging with the top subject matter experts, and we will begin to do that once we have finished this initial stage of the project. We are also dedicated to holding a comprehensive consultation process, and of course it will include patient and public interest advocates, centers of academic excellence, government agency stakeholders, professional bodies, other boards, as well as the FSMB. Our task force members are very dedicated to the project. They understand the urgency of it and have set us in a very ambitious target to deliver the project within 1 year, and the executive is dedicated to working towards that. I'd be happy to answer any questions.
Thank you, Mr. Prasifka, and thank you to Dr. Thorpe and Mr. Brooks for agreeing to serve on this important task force. Are there any questions or comments from board members?
Just a quick question, Bill. Have we identified the weaknesses in the current guidelines, the areas that we would have to have been improved in the quest for public protection?
Well, that's what we are doing now.
Oh,
I mean, I'm sure that our board members obviously have very learned directions, which they will be giving us on that. But this is what the executive now is going to be working hard with our subject matter experts to develop.
So we can give some suggestions as well.
Absolutely, of course, and we will be giving regular updates at board meetings. There will be opportunities for consultations, and of course, board members will be welcome to participate.
Thank you, Bill.
Additional comments or questions? All right, Sean, let's open that up for public comment, please.
Okay, the Q&A window is open for anyone wishing to make a public comment. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, hello, this is Hannah Ree from Black Patients Matter. No comments at this time, thank you.
Thank you for your public comment. Next up, we have Kristen Ogden. Kristen, are you there?
Yes, I am. Thank you. I want to make the point that I think this is very important and that stakeholder involvement certainly is going to be critical to development of a successful set of guidelines. Families for Intractable Pain Relief certainly does want to participate in any way that we can. A concern would be that the care of intractable pain patients, especially those whose illness has progressed to the syndrome we've discussed with multiple life-threatening complex complications, treatment of those patients requires more flexibility than the average typical chronic pain patient. And I think that it is very important that whatever words end up in these guidelines, that must be very clear that there will need to be flexibility and that there will be exceptions depending on the circumstances of individual patients. Unfortunately, as I'm sure all of you know, the CDC guideline was widely interpreted to be to have very little flexibility, although that's not necessarily how it reads if you go back and look at the document. And I believe that that has been used in a manner that has caused great harm to intractable pain patients, and especially those of Dr. Forrest Tennant. Dr. Tennant made the decision shortly after his facilities were raided to release the search warrant to patients, families, and the public. And so we all know what it says. And basically it gives the appearance that because some of Dr. Tennant's patients legitimately require very high doses to achieve pain relief and good function, good quality of life, that was interpreted as a signal that he was a bad actor. The fact that some patients traveled long distances to see him for care was interpreted as a signal that he was a bad actor. No one would think you're a bad actor if you travel a long distance to see a very renowned cancer doctor or a heart specialist. But the way the guidelines got interpreted influenced the decisions that got made about his care and his clinic, and have ultimately, although he has certainly never been charged with a crime and is regarded as a highly esteemed pain medicine expert, it caused a great deal of harm to him, his wife, and all the patients and their families for the last 4 years or so. So again, I realize that the CDC guidelines actually are read as guidelines and not fixed ceilings, but I just think that it points to the criticality of ensuring that we really say clearly what we mean as the medical board proceeds to develop its own new guideline. Thank you for the opportunity to comment.
Thank you for your public comment. And next up, we have Virginia Farr. Virginia?
Hi again. I think this is excellent and very much needed. My concern is being labeled a chronic pain patient when actually I had treatable pain is really concerning. I was just written off as forever chronic pain and there's nothing that can be done. And I just wonder how many patients are in that position in the standard of care and treating these patients. I went to 80 doctors in 2010, 80 doctors in 2011, and it took a doctor in 2013 to figure out the pain. And it took him half an hour. So I just wonder how many patients like me, especially with pelvic pain, are out there with treatable pain, but yet being treated with opiates that are very powerful drugs. So please consider that as well. Thank you. Bye.
Thank you for your public comment. Next up, we have Nicole Hendrickson. Nicole?
Hi, my name is Nicole Hendrickson. I am defense counsel for licensees before their boards. I just wanted to make a short comment. Has it been looked into whether or not we can revise the guidelines for prescribing controlled substances, period, rather than for pain? Because what I'm finding is that there's a lot of licensees who are unaware that these guidelines were also meant to prescribe or to apply to, say, benzodiazepines. And so I was wondering if the board could take that into consideration and make it a little bit more broad to prescribing all controlled substances, not just controlled substances for pain. Thank you.
Thank you very much for your comment. That is the end of the queue, Ms. Lawson.
Thank you. We'll bring it back to the board. Are there any additional comments or questions?
Ms. Lawson, it's Dr. Thorpe.
Please.
Well, first of all, I want to thank you for the opportunity to serve on this task force, and Mr. Prasifka, and just for the opportunity as well, and for Mr. Brooks's enthusiastic participation. I think we've heard a lot of concern about intractable pain, but I think there is and which is something we're very seriously going to consider, the whole issue of I think that the last suggestion by Ms. Hendrickson was a very good suggestion of looking at overall controlled substance prescribing policies as well. It is a challenge to come up with guidelines that are not interpreted by regulatory or payment, health plans, et cetera, as strict rules. And even though, as was previously pointed out, the guidelines that the CDC put out were guideline only, and that's what it says clearly in their statement. They've been interpreted and misinterpreted in many ways by making these morphine equivalent doses as absolute ceilings, et cetera, by many regulatory bodies, and in fact by our own investigating units as well. So we are looking at all those things, and I trust Mr. Prasifka to help us organize this process and to get the absolute best subject matter experts so that we can come up with a stellar process, and that California can be leading in this area of controlled substance prescribing, and our education and our both for patients and for clinicians as to what are the best practices and how to go through that process. So we are looking forward to this opportunity. Thank you.
Thank you. Are there any additional comments or questions? All right, hearing none, let's move on to the next item, item 24, update from the Board of Registered Nursing on AB 890.
Thank you. Okay, I'm connected. So my name is Loretta Melby, also known as Lori, and I am the Executive Officer for the California's Board of Registered Nursing. The update that I have today is that after the implementation of 890, we have established our Nurse Practitioner Advisory Committee. It does include 4 nurse practitioners, 2 MDs, and 1 public member. They have met twice. The first one was to vote on a charter and establish a chair and vice chair, and just briefly go over the implementation plan. And then the second meeting was actually held on Tuesday this week, where they divided into separate subcommittees. The first subcommittee's focus is on the 2837.101 section to work on developing a transition to practice. The second subcommittee is focused on the 2837.103. And then the third subcommittee is focused right now on the 2837.104. They have been tasked with getting together and working to have some kind of language, regulatory suggested language, to be presented on their next meeting, which will be held, next scheduled meeting, sorry, that will be held in August. In addition to that, they have requested that the board schedule a stakeholders meeting as part of their NPAC meeting, and that we are looking in July to get that scheduled. So once that is scheduled, I will make sure that it gets over to you guys, as well, as you are one of the stakeholders, and I'm sure that you guys will have a lot of information that you will add to that meeting. When they did choose the various smaller committees, there was a physician on each one, on 2 of the committees, I'm sorry, and then the final committee had a public member. So the delineation for one committee was a public member and a nurse practitioner. A second committee was a MD and an NP, and the third committee was an MD and an NP, to allow for various types of input for each one. They did accept the charters. The charters did go forward to the board meeting that we held yesterday and the day before. And there was no edits to the implementation plan that was presented to our board by our LEDGE committee back in November. So we are currently continuing to move forward, and we wanted just to give you guys that update that we've had 2 meetings so far, and they have established committees.
Thank you very much. Are there any comments or questions from the board? All right, seeing none, we'll open it up for public comment.
Okay, I've activated the Q&A window. Anyone wishing to make a public comment, please go ahead and type something in there or raise your hand. First up, we have Henry. Hannah, please go ahead.
Yes, hello. This is Hannah Ree with Black Patients Matter. I'm a little concerned about the nursing board not doing enough to advocate for underrepresented minority patients. So certainly we love and are very grateful to our nurses. I mean, my goodness, how much we rely on them. However, there are certain entities, hospitals, MLK Jr., a hospital in Los Angeles that are not hiring nurses who have experience in racially diversified patient populations. So I'm wondering why that type of irony is occurring at a hospital named MLK Jr. And I'm thinking maybe the Board of Nursing is not aware of these practices going on. And if they are aware, that maybe something can be done about it. And if in fact the leadership at the Board of Nursing is not aware of it, then it may be time for new leadership. Thank you.
Thank you for your public comment. At this time, I do not see any other requests in queue.
Thank you. We'll bring it back to the board. Are there any other comments or questions from board members? All right, seeing none, we'll move on to item 25. Discussion and possible action on modifications to previously approved text for rulemaking on postgraduate training requirements. Ms. Webb?
Thank you, Ms. Lawson. These proposed regs are being brought to the board to reconcile the previously approved language with the language that was ultimately noticed during the preparation of the rulemaking file. Staff determined that language that had been stricken, which required an applicant to be formally admitted, should not have been stricken. Staff thought that the documents necessary for the postgraduate training license would be sufficient, but determined that there are actually people who are not formally admitted who try to seek credit for postgraduate training. And so that description in there is very important. And so that is the language that was noticed. Now we are nearing the end of the rulemaking process. It is with the Office of Administrative Law. They are prepared to approve it with the board's approval of the ultimately noticed language. We've also made non-substantive changes requested by the Office of Administrative Law for consistency with statute. And so with that, I would request a motion to approve the noticed language for 16 CCR section 1321 with the additional non-substantive changes required by the Office of Administrative Law, and authorize staff to make any additional non-substantive changes required to complete the rulemaking process without having to return to the board.
So move.
Second.
Motion from Dr. Kraus and a second from Dr. Lewis. Is there any discussion from the board? All right, I'll open it up for public comment. Do we have any public commenters?
I've gone ahead and opened up the Q&A window and the raise your hand function again. If anyone would like to make a public comment, please indicate so. We have Hannah. Hannah, please go ahead.
Yes, thank you. Thank you, medical board members, for putting up with me. I sincerely thank you. So as far as the language that's being put forward in regards to postgraduate training, we find that our hope is that as part of postgraduate training, that training institutions must document that students have received training work hours in a racially, religiously diversified patient population, as well as an LGBTQ diversified patient population. And so certainly, if it becomes mandated federally in the next few years, I hope you all remember where that thinking originated. I thank you.
Thanks for your public comment. I do not see any other requests in queue.
Thank you. We'll bring it back to the board. Is there any further discussion on the motion and second? All right, seeing none. Ms. Caldwell, if you could please call the roll.
Mr. Brook?
Aye.
Ms. Campoverde?
Aye.
Dr. GnanaDev?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Aye.
Ms. Lubiano?
Yes.
Dr. Lewis?
Aye.
Dr. Mahmood?
Yes.
Mr. Ryu?
Aye.
Dr. Thorpe?
Yes.
Mr. Watkins?
Aye.
Dr. Yip?
Aye.
Thank you.
All right, the motion carries. Thank you. We're now moving on to agenda item 26, which is, excuse me, discussion and possible action on proposed regulatory language implementing SB 697 relating to physician assistants. Ms. Webb.
Thank you, Ms. Lawson. Proposed regulations that are propounded by the Physician Assistant Board that have to deal with scope of practice and physician supervision must go through the medical board for review and approval. And so the Physician Assistant Board has proposed amending regulations to be consistent with SB 697 that became effective on January 1st, 2020. And at this time, I know that the president of the Physician Assistants Board, Juan Armenta, is on the line. And so I would like to invite him to speak briefly on the proposed regs.
That's great, thanks.
Mr. Armenta, your line is open. If you can go ahead and unmute.
Yes, I unmuted. Thank you very much. This is Juan Armenta. I'm the current president of the Physician Assistant Board. I hope my audio level is okay.
You sound good.
Okay, thank you. As most of you know, Jed Grant was deployed to Iraq, and that resulted in my election to take the president's board. In producing the regulation packet that's before you, we had an excellent meeting a couple of months ago with COPPA and their representatives. We are on a pathway to really cooperating with them and producing regulatory packages. I did understand that there was a concern raised recently about one component that was not discussed at our meeting. And I had a conversation with Brett Bergman just a couple of days ago, who is the COPPA president, the California Assistant Physicians Association. And we are in agreement that if there are to be any further tweaking of regulatory language, it belongs before the PAB before we produce it over to MedBoard. So that would conclude my comment, and just would like to advise the board that we do have what appears to be an excellent relationship with the new leadership over at COPPA, and particularly with regard to working on these regulatory packages. And that concludes my comments. Thank you, Madam President.
Thank you very much. Are there any questions or comments from board members?
I'll make a motion to approve the proposed regulatory language implementing SB 697 and all the code sections that are listed in our agenda.
May I help further the motion, Dr. Lewis?
Yes, please.
And to direct staff to work with the physician assistant board to take all steps necessary to initiate the rulemaking process, authorize staff to make any technical or non-substantive changes to the rulemaking package without returning to the board, and notice the text for a 45-day comment period. And if there's no adverse comments, to proceed with completing the rulemaking process to adoption without returning to the board.
Yes, that's all that I was going to say too.
I knew it.
Yeah, thanks.
Second. Mr. Watkins has the second.
Ms. Lawson, I just had a question to Ms. Webb or to the president of the PA Association. Currently, my understanding is that there's a limitation of 4 PAs to supervise for any given physician. And I just wondered if that is still going to be part of the regulatory language. And the change, the substantive change in this regulation is that PAs don't have to be in the same facility as the supervising physician, and that supervision can be done electronically, and there's no mandate for the physician to be present. I just want to make sure I understand that clearly.
Okay, the two parts to their to that those questions. The first part with the number of PAs that can be supervised, that is not addressed in these regulations. There is, I believe, still a current waiver under DCA in light of the pandemic, but that I would be happy to verify that that is still in effect and get back to you, Dr. Thorpe. But the number of PAs that can be supervised by one physician is not addressed in this package. The piece about being present, you are correct with one exception, and that is where there's a procedure being done under general anesthesia. The physician needs to be immediately available, and that is defined, and this is under 1399.541, which starts on page 26-6 of the materials. Immediately available means the supervising physician is physically accessible and able to return without any delay upon the request of the physician assistant to address any situation requiring the supervising physician's services. Now, this is existing language. The only thing that's being changed in the proposed regs is putting the supervising in front of physician there. But I did want to make that clear that that's still part of this regulation.
Yes, this is Juan Armenta, the PAB board president. I agree completely with Ms. Webb's analysis.
Any additional questions or comments?
I'm sorry, I just had one other question, and that is the policies and procedures that are mentioned here. Is there any movement on the part of the PA community or the family medicine or internal medicine community to come up with a sort of a template for those supervision policies and procedures, or is that something that the medical board should consider doing?
Mr. Armenta, I'll leave that to you.
Thank you, Ms. Webb. I'm not sure I understand the question in terms of a template, and understand that my profession is a lawyer, not a PA or a MD. So maybe you can explain that to me.
So I'm sorry, I'm just reading this for the first time myself, but I guess my question is that there is a mention here of the since that my understanding, what I understand is the practice agreement that is mentioned here that defines the medical services the physician assistant is authorized to perform and grants approval for them. That practice agreement, is there any because in actual practice, it's been delegated to the individual physician based on their scope of practice. And so if a PA works with a internal medicine doctor, then their scope of practice is kind of the scope of practice of the physician. My question, I guess, is there's been quite a bit of latitude in that what physician assistants are allowed to do based on who's supervising them. Some of them are dermatology PAs, some of them are cardiology PAs, some of them are other types of PAs, some of them are surgical, orthopedic, etc. And their scope is determined by their supervising physician. I guess the question I have is there any is there a restriction now on these practice agreements that would affect those relationships?
I interpret your question to mean is, I guess, is there a template with regard to those practice agreements? I'm not aware of any, nor has the board at this time taken a position, as far as I can recall, as to what that practice agreement needs to look at, other than consistent with the enabling statute. That is certainly something we can look at and put on our agenda in the future, but I do not have a definitive answer with respect to a template or what that agreement might look like, other than within the confines of the statute.
Thank you.
Additional comments or questions? All right, I believe we have a motion. Have we taken public comments yet? We have not taken public comments yet. We'll move to public comment.
Thank you. The Q&A window is open. If anyone would like to make a public comment, please indicate so. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, hello, Hannah Ree here with Black Patients Matter. Previously, I had made a comment about PAs, physician's assistants. My understanding is still that they must work under the guidance of a licensed physician in the state of California, in which case, in terms of African-American patients, underrepresented minorities, the hope is that PAs, and there are just a large number of very highly qualified PAs, can at some point work independently and not have to be supervised by a licensed physician. Thank you.
Thank you for your public comment. Up next, we have Ed Howard. Ed, are you there?
I am. Can you hear me?
Yes, we can. Please go ahead.
Hi, good afternoon, President Lawson and board members and President Armenta. Ed Howard on behalf of CAPA. I just wanted on behalf of PAs throughout California and members of CAPA to thank the PAB and its staff and President Armenta and former President Grant in particular. Just like to affirm that we've had really collaborative conversations with the PAB and its staff, and we look forward to working them in the future on more efforts to conform regulation and practice with SB 697. Thank you again.
Thank you for your public comment. At that time, that's all in the queue.
Thank you. Thank you, Sean. We'll bring it back to the board. We do have a motion from Dr. Lewis, and I apologize. I forget who the seconder is.
It was Mr. Watkins.
Mr. Watkins, thank you. Is there further on the motion? Ms. Caldwell, please call the roll.
Mr. Brooks.
Aye.
Ms. Campaverde.
Aye.
Dr. GnanaDev.
Yes.
Dr. Hawkins.
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms.
Yes.
Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Dr. Mahmood, thank you. Mr. Rue,
Yes.
Dr. Thorpe,
Yes.
Mr. Watkins,
Aye.
Dr. Yip,
Aye.
thank you.
Thank you. The motion carries. We'll move on to the next agenda item, which is item 27, discussion and possible action on proposed regulatory language to amend the licensed midwife annual report.
Thank you, Ms. Lawson. The Midwifery Advisory Council has approved proposed language to add a requirement for licensed midwives to report in their annual report their client's race and ethnicity as identified by the client. Right now, no such data is collected on licensed midwives' clients regarding their race and ethnicity, and the Midwifery Advisory Council determined that this is an important piece of information. And so we worked with them to craft the proposed addition. And Ms. Lawson, would you like me to suggest a motion?
That would be great.
Okay.
Is there from the advance or just take that during public? Oops. Can you not hear me?
Sorry. You cut out. I can suggest a motion and then the discussion can continue after that. But
that'd be fine. Thank you.
The motion would be to direct staff to prepare the necessary regulatory documents to submit to the Department of Consumer Affairs and Business Consumer Services and Housing Agency, and upon DC and agency approval, to submit the documents to the Office of Administrative Law to notice the proposed regulatory language to add section 1379.35 to the California Code of Regulations, and to authorize staff to make any non-substantive changes to the language and respond to non-substantive comments during the rulemaking process without returning to the board.
So moved.
Who is that? Dr. Thorpe?
Second.
Second by Dr. Lewis. Thank you both. Is there any further discussion before we open public comment?
Yeah, Ms. Webb, if the patient wants an option not to disclose, they have that right, correct?
Yes, because it would be as disclosed by the client. If they did not respond to that, then that's how the licensed midwife would report it.
Okay, thanks.
I'm sorry, I'm having internet connectivity issues, but is there any further questions or comments? You can open it up to the public, please.
Okay, I've gone ahead and opened the Q&A window for anyone wishing to make a public comment. Please indicate so there or raise your hand. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, hello, Hannah Ree here with Black Patients Matter. So in regards to listing the patient's race and ethnicity, so it sounds like it is voluntary information, but also as far as the language of it, I surely hope that we're going to be very specific. So as we recall, there was a presentation that was done in regards to mortality, morbidity rate of newly delivered new mothers. And Dr. GnanaDev had mentioned that he was surprised that the mortality rate of Hispanic women was very similar to whites. In which case I had mentioned that being Hispanic is not a race, it's an ethnicity. So And that, of course, resulted in a federal lawsuit because afterwards he told me to shut up and don't ever say something like that again. In any event, my comment is that I surely hope when this is listed on the questionnaire for the patient, that you specify their race and or their ethnicity. You cannot put race and ethnicity in the same column because there's no increase mortality rate associated with ethnicity per se. It's with race. Thank you.
Thank you for your public comment. At this time, I don't see any additional requests in queue.
Let's bring it back to the board, please.
Ms. Lawson, can you hear us?
Your audio is very faint, Ms. Lawson, if you can.
Can you hear me now?
Yes.
Yeah.
All right, I'm sorry about this. All I was asking was for whether there's additional comments or questions from the board. All right, seeing none, I think we can move to the roll call vote. Valerie, please.
Mr. Brooks,
Aye.
Ms. Campaverde,
Aye.
Dr. GnanaDev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Mr. Ryu,
Aye.
Dr. Thorpe,
Yes.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
Thank you.
All right, thank you. The motion carries. We are now going to move on to item number 28, update, discussion, and possible action on proposed agenda from the Midwifery Advisory Council. Ms. Holzer.
Thank you and good afternoon to everybody. So our requested action today is to establish goals for the MAC.
Ms. Holzer, I'm sorry. Could you speak louder into your microphone? We're having a very hard time.
Yes, okay. I'll get a little closer. Good afternoon. My name is Diane Holzer. I'm a licensed midwife and chair of the Midwifery Advisory Council. We're here today to get approval for our upcoming agenda for our council meeting. We're asking for the following agenda items to be approved: establishing goals for the MAC, update on midwifery related legislation and sunset review, report from the MAC chair, update on the midwifery program, update on proposed regulatory language for the licensed midwifery annual report, that LMAR, discussion on training for MAC members, approval of the minutes from the March meeting, selection of one new MAC member, the public member position, report from the task force, and discussion regarding Medi-Cal related issues. The background was that our last meeting was held on March 11th, 2021. At this meeting, the following actions were taken, or we were provided with the following information. We approved the meeting minutes from the December 3rd meeting, received an update from the chair. We appointed a new member to the task force on Medi-Cal related issues, received an update on midwifery legislation and sunset review. We received an update on the midwifery program, voted to recommend to the board the reappointment of Claudia Breglia to the vacant licensed midwife position on the MAC, and we voted to recommend to the board the new proposed regulatory language regarding the data collected on the LMAR.
Thank you. Are there any questions or comments from board members? All right,
Yes.
I'm hoping you can hear me. Sorry,
Yes.
Mr. Watkins, go ahead.
So let's move to approve the agenda for the next MAC meeting.
Second that.
Thank you. We have a motion for Mr. Watkins, a second for Ms. Campaverde to approve the MAC agenda. Any further discussion before I open it for public comment? All right, hearing none, Sean, please open it for public comment.
Okay, we have the Q&A window open. The first request I have here is from Hannah Ree. Hannah Ree, please go ahead.
Yes, hello, Hannah Ree with Black Patients Matter. We just could not hear really anything she had said. So I don't know if anyone cares enough to problem solve it, but we could not hear. And so therefore we are unable to comment. Thank you.
Just so it's clear, it came through once she got closer to her microphone, but the audio will be available later on when we post the video as well.
Well, I also basically just read the report, which is posted on the website.
Okay, thank you, Ms. Holzer. At this time, I don't see any other requests in queue.
Thank you, Sean. We'll bring it back to the board. Or is there any additional board comment or question on the pending motion? All right, seeing none. Ms. Caldwell, would you please call the roll?
Mr. Brooks,
Aye.
Ms. Campoverde,
Aye.
Dr. GnanaDev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Mr. Ryu,
Yes.
Dr. Thorpe,
Aye.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
Thank you.
All right, thank you. The proposed agenda from the Midwifery Advisory Council is approved. Moving to the next item, 29, discussion and possible action on recommended appointment of Claudia Breglia to the Midwifery Advisory Council. Holzer again.
I so move that we recommend appointment of Claudia Breglia to the Midwifery Advisory Council.
I second.
Again.
I second, Dr. Mahmood.
Yeah.
Ms. Lawson, we're having
Sorry,
trouble.
Were we going to hear from Ms. Holzer again? Can you hear me?
You're coming through now, yes. Ms. Holzer's line is still active if she's there.
Yes, no, but I was going to recommend that you authorize her so that if the motion is on the floor, that's perfect.
Thank you. We have a motion from Dr. Lewis and a second from Dr. Mahmood, I believe. Is there any further discussion? All right, seeing none, we'll open it for public comment, please.
Okay, the Q&A window is open for anyone wishing to make public comment. First up, we have Hannah Ree. Hannah Ree, please go ahead.
Yes, hello, Hannah Ree here, Black Patients Matter. You know, I'm concerned about the leadership here. Out of respect for the person that we're nominating, I could not even hear her name. Miss Lawson had cut out, and then I feel like I'm having these visions of her because she keeps disappearing, and this is, you know, kind of this interrupts the flow of the meeting. So I hope we can problem solve this. If maybe someone cares enough to repeat who we're nominating, that would be gracious enough. Thank you.
Thank you for your public comment. At this time, I don't see any other requests in queue.
Thanks, Sean. My apologies for the connectivity issues, and to the extent they continue, I'd be happy to have Dr. Kraus facilitate. We do have a motion on the table to approve Claudia Breglia to the Midwifery Advisory Council. Is there any further discussion? Hearing none, Ms. Caldwell, let's move for a vote.
Mr. Brooks,
Aye.
Ms. Campoverde,
Aye.
Dr. GnanaDev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Miss Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Mr. Ryu,
Yes.
Dr. Thorpe,
Aye.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
Thank you.
Thank you. The motion carries, and congratulations to Ms. Breglia on her appointment. We will now move on to the next item, 30, discussion and possible action on 2022 proposed board meeting dates. Mr. Prasifka?
Thank you very much, Madam President. My presentation here is very brief. We need to set the board dates for the meetings for next year. Because of the need to space board dates in a manner to facilitate its conducting official business, the board members have basically two suites of dates to begin with. These are at page 30 of your board meeting notes, or this is item 31. The first one begins February 10th, 11th, and there are 4 dates there. And then the next one is February 24th, 25th. So it's really picking between those two separate sets.
Thank you, Mr. Prasifka. Is there any comment from the board members?
This is Dr. Thorpe. Just because of the proximity to the end of the year holidays, I would be in favor of the first set of dates. And I'd be willing to make a motion to accept that first set of dates.
Thank you. Is there a seconder for that or any further discussion?
Second.
This is Lori. Oh, I was going to second.
Because these are dates for our board meetings, I'm just going to ask if there's any objection to those dates by any board members or anyone who sees a significant conflict with any of those dates before we move to public comment. All right, hearing none, let's please move to public comment.
Okay, the Q&A window is open for anyone wishing to make a public comment. Please do that or raise your hand and we'll call on you in the order received. Henry, you're up.
Yes, hello, this is Hannah Ree of Black Patients Matter. When we have the meetings, I understand we're talking about the dates, and so I don't really see a conflict on our part, of course. But you know, with all of our budget concerns with the medical board, I'm wondering if it's time, perhaps, if we should utilize facilities of nonprofits in order to save money, and also for nonprofits, places like churches or so many nonprofit organizations across the state of California that have lower fees, have great facilities, and that it would be helpful to the community that we're visiting in the different places in California. So that's what I wanted to put out there instead of going to expensive hotels. Okay, thank you.
Thank you for your public comment. At this time, I don't see any additional requests.
Thank you. We'll bring it back to the board for action or further discussion on the motion. Is there any further discussion about the proposed board meeting dates? All right, hearing none. Ms. Caldwell, will you please call the roll?
Mr. Brooks,
Aye.
Ms. Campoverde,
Aye.
Dr. GnanaDev,
Aye.
Dr. Hawkins,
Yes.
Dr. Kraus,
Yes.
Ms. Lawson,
Yes.
Ms. Lubiano,
Yes.
Dr. Lewis,
Aye.
Dr. Mahmood,
Yes.
Mr. Ryu,
Yes.
Dr. Thorpe,
Aye.
Mr. Watkins,
Aye.
Dr. Yip.
Aye.
Thank you.
Thank you. The 2022 proposed board meeting dates are approved. We will now move on to agenda item 31, which is election of officers. I would like to ask for nominations for vice president, and I would like to do so because Dr. Howard Kraus will be leaving the board sometime between now and our next board meeting due to his term expiring. And so I'd like to ask for nominations for his position as vice president.
I nominate Randy Hawkins.
I'd like to second that.
Do we have any additional nominations? All right, nominations are now closed. I will now ask the host to call for public comments.
Okay, I've opened the Q&A window for anyone wishing to make a public comment or raise your hand, and we'll call on you in order received. First up, we have Hannah Ree. Hannah, go ahead.
Yes, thank you. Hannah Ree of Black Patients Matter. So back in the day when I was a licensed physician in the state of California, before I was revoked, I did have the pleasure and the honor of having met Dr. Kraus at the CMA meetings. And he's a wonderful physician who's, of course, very brilliant, hardworking, wise. And so it's been a pleasure working before him, against him, with him as a advocate at these medical board meetings. So it's going to be.
Ms. Ree, this is on the topic of Dr. Hawkins' nomination. So
yes.
Please keep it on topic.
Yes, thank you. I thank you, Carrie, for doing that. Yes, so of course, no problem. He's wonderful, brilliant. It's time. It's past due time to have Dr. Hawkins as vice president. Thank you.
Thank you for your public comment. At this time, I don't see any other requests in queue.
Thank you. So I will bring it back to the board for any further discussion. I guess that's the proper procedure, Carrie, although I'm not sure on nominations for election of officers. Is the proper procedure now to just call for a roll call vote on the nomination of Dr. Hawkins to the office of vice president? Great, thank you. Thank you. Ms. Caldwell, please perform the roll call vote.
And that's assuming he's accepted the nomination. I didn't hear him say.
Thank you.
I don't want to get ahead of myself. I'm extremely pleased and proud to be able to accept this role and do my part to contribute to the growth and development of the Medical Board of California.
Thank you, Dr. Hawkins. Ms. Caldwell, please perform the roll call vote.
Mr. Brooks.
A resounding aye.
Ms. Campoverde.
Aye.
Dr. GnanaDev.
An enthusiastic yes.
Dr. Hawkins.
Yes, thank you.
Dr. Kraus.
Yes.
Ms. Lawson.
Yes.
Ms. Lubiano.
Yes.
Dr. Lewis.
Aye.
Dr. Mahmood.
Yes.
Mr. Ryu.
Yes.
Dr. Thorpe.
Yes.
Mr. Watkins.
Aye.
Dr. Yip.
Aye.
Thank you, and congratulations to Dr. Hawkins. I look forward to working closely with you in the coming weeks and years. Given that Dr. Hawkins is now the board's vice president, he cannot also serve as the board's secretary, and I'd like to ask for nominations for secretary.
I nominate Ms. Lubiano.
To go first, and great. I would like to second that nomination, Dr. Kraus.
Second, Dr. Yip.
Thank you. Are there any additional nominations? All right, hearing none, I'd like to ask the host to call for public comments.
Okay, the Q&A window is open for anyone wishing to make a public comment. First up, we have Hannah Ree. Please go ahead.
Yes, Hannah Ree of Black Patients Matter. Very excited to see Ms. Lubiano's nomination. She, thinking of her reminds me of the time she shared her own personal stories about healthcare, and she became quite tearful. So I know she has a very good heart, and she really does think of patients first. So congratulations on the nomination. Thank you.
Thank you for your public comment. I don't see any other requests in queue.
Thank you, Sean, bringing it back to the board. Ms. Lubiano, I will confirm with you that you'd like to accept this nomination for the position of Secretary of the Board.
Absolutely, yes. Thank you.
Thank you. And are there any additional comments to the roll call? Valerie, please.
Valerie. Yeah.
Mr. Brooks.
If you're an absolutely yes, I'm an absolutely aye.
Ms. Camporetti. Dr. GnanaDev.
Another enthusiastic yes.
Dr. Hawkins.
Yes, definitely.
Dr. Kraus.
Yes.
Ms. Lawson. Ms. Lawson.
Yes.
Thank you.
I can hear you. Can you not hear me?
I can now. Thank you.
Thank you.
Ms. Lubiano.
Yes.
Dr. Lewis.
Aye.
Dr. Mahmood.
Yes.
Mr. Ryu.
Yes.
Dr. Thorpe.
Yes. Yes.
Mr. Watkins.
Aye.
Dr. Yip.
Aye.
Thank you.
Thank you. And congratulations to Ms. Lubiano. We look forward to the position as the Budgetary. We are moving now to item 32, future agenda items.
Madam
Do
Chair,
any members have future agenda items?
may I ask for a point of personal privilege?
Please.
To paraphrase an often misattributed quote, I regret that I have but 2 terms to give for my medical board. On June 1st, my service concludes. My parting gift is for each board member, board executive, board staff member, and board partner and consultant to know you have my respect, admiration, and love. Even in the face of difference of opinion, each of you has demonstrated a commitment to public protection which transcends your own personal interest and well-being. You have each been analytic, critical, self-critical, and soul-searching in service to the higher interest of public protection. Thank you for sharing and carrying forward this most important mission. Thank you, Ms. Lawson.
Thank you.
Thank you, Dr. Kraus, for your service to the board and to the public.
Howard, I'll
Dr. GnanaDev?
Yeah, thank you, Madam Chair. So Howard will miss you on the board, but now I don't have to hesitate in calling you because we're not communicating about the board anymore. So I'm just for the rest of you, I know Howard for over 20 years. So it's I'm going to miss you, Howard.
Thank you, Dev.
Ms. Lawson, this is Dr. Thorpe. I would just like to add my expression of respect and my real we really appreciate your humor and your wisdom, Howard. We will miss you, and I personally will miss you greatly as well. Thank you.
Thank you.
Dr. Hawkins, briefly. Howard, we've become close friends. I do appreciate your humor, your sarcasm. It's good. And we have a jazz date to be filled.
Great.
TJ, I, Dr. Kraus, I just want to say a deep gratitude. Your example has made me want to be better, and an inspiration. You're pretty brilliant, and I have been honored to serve with you. Thank you.
Thank you, TJ.
Dr. Kraus, Howard, Felix, we have the same shirt, but we don't have the same mind. I'm way, way below yours. You're a big inspiration. I'm always trying to do almost as good as you are, but I'm still trying. Good luck to you.
Thank you, Felix.
Lori here. Briefly, just wanted to say thank you, Dr. Kraus.
All
was
right.
Too short.
Should we bring it back to?
Sorry, I just wanted to say thank you again. It's been an honor.
Shall we bring it back
work
to
with
future
you.
agenda items?
Yes. Thank you all. Please proceed.
Madam Chair, I do want to add the staff to bring us back the physician training license. There are some issues. We heard that here. We heard that in the PNP committee meeting. I think we can clean it up, but I want it brought in front of the board to see how we can clean it up. I have some ideas. I'll send it to the staff. I think it's a good thing we did, but it has some issues, and we need to solve those issues. It's important.
Thank you.
I'd love to
Still
add
future agenda items.
Yes, I'd like to add one on an update on timeline proposed and progress for the web tracking system.
Thank you. Dr. Yip, did you have your hand up?
Yeah, I'd like to reiterate if we can look into what is feasible panel meeting can be monthly. I think they help to cut down the caseload and also increase the like licensing public protection so that they won't be dragging on. So, thank you.
Dr. Hawkins. It was a bit hard to
Right,
understand. I'm sorry.
Please. We did not hear what Dr. Yip asked for. Can we have Dr. Yip say that again, please?
Yeah, I was asking whether it's feasible for panel meeting be monthly rather than quarterly. I personally feel that it would help to cut down the caseload. Thank you.
Dr. Hawkins?
Yes, it was hard to understand her, but I think that in some fashion, Dr. Khadija Lang wanted us to revisit the disciplinary demographic study. So sometime in the future, figure out how to look at that again.
Thank
Dr.
you. Yes,
Mahmood?
that was her suggestion. Dr. Mahmood?
Yeah, so I want to be sensitive to the public, and I think in future, pretty soon, we'll be having in-person meetings. So we can pick places which are more affordable to everybody and public can afford to, and especially the parking is not way too expensive. I think meeting in San Diego was really a place where it was very expensive parking. So we have some due diligence and respect for anybody and everybody who attends that meeting. So
Thank
meeting
you.
venues should be sensitive.
Thank you. Any other future agenda items?
Lori here. I had a future agenda item, please.
Fluvian.
Thank you. At the last meeting, Dr. Kraus and I requested, and I'd like to put in the request again for a discussion about cultural competency. What it's like at the different medical schools, but also what we can do to make it a requirement. And I asked specifically also because I recently read an NBC article that did a survey across the United States. And the result of the survey was that 42% of the people could not name a famous Asian American. And another result was that 1 in 4 Asian Americans don't feel respected. And it's not just about Asian Americans, but it's cultural competency overall. And I think it's an important issue. Thank you.
Thank you. Additional items?
Yes. Oh, sorry.
Ryan?
Yeah, okay, thanks. I would like to look at, I don't know how much time or this would take, but we've had a lot of conversation over the last couple of days about, disciplinary actions deviating from the guidelines and, public safety, which is our mission. I wonder if it's possible to get the statistics from 2001, so approximately 10 years ago. How many of those disciplinary cases where disciplined a physician has come back to this board? So I'm trying to figure out what the recidivism rate is. And I don't know if that is possible, but it would be nice to have a snapshot so we can look back 10 years. But just looking at 2001.
And
Ms. Lawson's losing connectivity.
Did staff record Mr. Brooks's request?
Yes, I heard it. I'm sorry, it wasn't letting me unmute on my computer. Sorry about that.
I have one.
Mr. Watkins.
The last one, I would like to have an expert or someone in this space talk about alcohol use disorders specifically.
Thank you. Additional agenda items?
For staff, Ms. Lawson, I think what Mr. Brooks asked, there are enough students out there in Sacramento, UC Davis. They will be happy to do this kind of work. So it's work with one of the universities. They can do it for you.
Yeah, I just want to be very clear. Thank you, Dr. GnanaDev. I just want to look at 2001 and see if we had 250 cases. And then from then to today, how many recidivism cases did we have? Because that will just kind of give us a snapshot on whether our guidelines, we can do some further analysis, because Mr. Watkins had some great ideas. And I want to be able to say, and then we'll take those numbers and then look, did we increase the penalties, decrease the penalties, and sort of get some correlation? And so we can kind of figure out decisions or what the cause and effect of our decisions. But I think I would love to have that first step done. So thank you for that suggestion.
Yeah, agree. And actually, in the end, AI might help into that. What type of people are the one which are becoming what type of disciplines? There's a lot of value. What you're asking is absolutely correct in the 21st century.
Thank you. Any additional future agenda items from board members before I ask for public comment? All right, hearing none, would you like to open the line, Sean?
Yes, it's been open. So anyone wishing to make public comment, please indicate so in the Q&A box or by raising your hand. We'll call in the order received. First up, we have Hannah Ree. Hannah, please go ahead.
Yes, hello, Hannah Ree with Black Patients Matter. So as far as future agenda items, I think medical board, it is time for us to bring in the AG's office to audit them and to find out why they are so expensive, getting more costly, and we're not getting good results. And then also we need to do some type of retrospective study to see if in fact the cases that we are choosing or have chosen or the processes that we have been doing are in fact decreasing recidivism rate. But argue that asking for the number of cases from 2001 to the present would be skewed. Why? Because a significant study had come out that showed that the medical board or the AG's office or HQIU, whomever, had targeted African-American physicians at a proportion, a significantly higher rate than other doctors. So I believe that has since been, it's correcting itself now with the changes that Mr. Prasifka has put in. But I do want to argue that if we look at recidivism rates, that there has been a study that's shown that physicians of color have been targeted. And then also, since we brought in, we had a wonderful conversation today with the presentation from Carrie, but now it's time to bring in the OAH and the DAG to answer questions, because it's hard for me to say this, but there is corruption within the OAH's office. And I don't know if our budget covers them at all, but the AG's office definitely has got to be brought in to answer why they are getting to be so expensive and we're not seeing good results. Thank you.
Thank you for your public comment. Next up, we have Susan Lauren. Susan, please go ahead.
Thank you. I have a few things to say. One is I've requested some kind of a focus on adipose removal. Now, I don't know how that would work because what you've got is a bunch of doctors that are going to come and lie about it. And we've got a lot of people worldwide that are suffering. I can certainly share my story of having what's going on. I know you don't seem interested, and there seems to be a strong bias against, I didn't go for liposuction, but a lot of people do. They go for that specifically. And so I don't want to talk about just, hey, I went for breast reduction and, you know, this guy talked me into, hey, we're going to do this little bit of balance just on this spot on the side of your hip, and then he mutilated my whole body. But a lot of women go for breast reduction and they're upsold on, and they're told the same thing, we need to do this for balance. But I've been sharing with you for all these years about the bad effects that happen. Adipose is an endocrine organ. And to just keep ignoring that when we remove it, that was my number one question, because I had been referred to breast reduction for like 25 years. First of all, I liked having large breasts. You know, we don't like I don't like talking about my body parts, but that's what he did. That's what I went in for, and we're the medical board here. I didn't want scar tissue, I didn't want surgery, and I said, look, if you remove a little bit from my breast, isn't that going to change my hormonal balance? Because that's where a lot of the estrogen is. Estrogen is also in the butt and the hips. I don't know how we would present this topic, because there's a doctor that I've heard several times talk. He's a plastic surgeon. I don't feel like I need to name him right now, but when you have the talk about cosmetic versus plastic surgeons, you know, that whole talk you have about should we license cosmetic surgeons, he comes and talks, you know, going full bat for the plastic surgeons. He's someone that I saw after Sahlberger mutilated me. Now, what he did is he looked at me and he said, this is surgical assault, and he referred me to a lawyer. Now, instead of going to bat for plastic surgeons, I think that guy and everyone else, they're seeing destroyed bodies all the time, and that's the fact. And they're not talking about it. They're just protecting themselves and each other. And I don't know what to do. As you can see, I'm doing everything I can. It's myself that would have been saved if this had been done before me. Okay, so I don't know how to present that topic. The other thing is, you can't be tracing recidivism on someone like Berger, who doesn't even. It doesn't make sense to me at all that this guy mutilated me alive and you do nothing. And that every day that goes by that you don't address that is it's torture. And it really is sick. If you went in for any kind of operation, you came out without your butt, would that be okay with you? That guy should not be working. We need to address it somehow, because you can't keep going on like this. Thank you.
Thank you for your public comment. Next up, we have Michelle Montserrat-Ramos. Michelle, are you there?
Yes, I am. Michelle Montserrat-Ramos with Consumer Watchdog. We appreciate Mr. Brooks' suggestion. Can we take back the study to 25 years and also include the number of complaints that did not reach an accusation level or were dismissed to the study, which will give you a better overall picture? 1. 2, also, please include the probation violation issue that Mr. Watkins requested at the February meeting. Thank you.
Thank you for your public comment. At this time, I do not see any additional requests in queue.
Thank you, Sean. I will bring it back to the board. Are there any additional future agenda items that board members would like to raise? All right, hearing none, we are going to move on to our last agenda item, which is adjournment. But before we do that, I would also like to acknowledge that this meeting is also Dr. Lewis's last meeting for the same reason as Dr. Krause's last meeting. And Dr. Lewis, I would just like to express how much I have enjoyed working with you. We've served on the board since I joined in 2015 together, so for about 6 years, and I've really enjoyed every minute of it, and I'm sure there are others who want to say something as well.
Hey, Ron, it's so sad to miss you. I was hoping that both you and Howard got reappointed. Unfortunately, your terms are up and no more terms left, so we'll truly miss you, but at least you live in Palm Springs and we can get together sometime.
Thank you very much.
Ron, you and I have overlapped coincidentally, and most of our fellow members on the board don't know that we share our name. But you are Ronald Howard, and I am Howard Ronald. So it's been a fun Lewis Krause expedition, and I wish you the best going forward, Ron.
Thanks for being a friend.
Dr. Hawkins? Yeah. I just want to just briefly state how valuable you were to me, particularly in the beginning. A lot of folks don't realize there's a lot of education that occurs in those panel meetings. And so you were extremely helpful in me learning how to navigate the evaluation. I appreciate you for that.
Okay, you're most welcome. Thank you. I enjoy your friendship.
And if I may, I also want to thank you, Dr. Lewis, for your service. And you were the first, I think the first board member to reach out to me, to welcome me to this board. And I won't forget that. I wish you the best of luck, and I hope we can keep in touch.
Okay, thank you. You good luck with your career on the board. I know you'll do very well.
TJ, I just want to say a heavy duty thank you to you for having led us in the panel A discussion and doing a great job. And I know there's been a lot of assaults on you from the other side. And I just want to wish you all the best, all the strength, and, you know, may you just have a more peaceful space. I really appreciate you. Cheers.
Thank you. Yes, peaceful times now ahead after today. Thank you for your acknowledgement and your friendship very much.
Hi, Ron. I can attest you're a very committed board member. I know you spend time reviewing cases, very reasonable, warm person. I will miss you very much, Ron.
Thank you, Philip. Yes, I know most of us have not seen eye to eye on some of the cases, but we learn from each other. And that's why I hope the new board members will learn from the seasoned board members and take that knowledge with them in their career on the medical board.
Ms. President, Dr. Thorpe. Yeah, I just want to add my congratulations to a term well served, Ron. Grace under fire, and thank you for your friendship for the short time I've been on the board. It's been a pleasure, and I wish you well.
Thank you, Richard. I appreciate your comments, and I know we've had discussions as in your early career on the board, and I think you'll be a very, very good, excellent board member. So wish you well.
Okay. All right. Unless there are any final comments, the board meeting is now adjourned. Dr. Lewis and Dr. Krause, thank you again. And
Thank
I hope to see you all soon.
I wish you all the best of luck, and I very much enjoyed your camaraderie and friendship. and I will not forget this. Thank you.
Thanks, Ron.
Thank you.
Thanks, Howard.
We'll see you all next time.
Thank you.